The Senate will come to order. Senator Fateh.
Thank you, Mr. President. I impose a call on the Senate.
The Senate is now under call. Senator Murphy.
Thank you, Mr. President. I move that further proceedings under the roll call be dispensed with and that the Sergeant-at-Arms be instructed to bring in the absent members.
On that motion, all in favor say aye. All opposed say no. The motion prevails. Members, if you would be so kind as to stand. Members, as you know, it is our Senate tradition to start with prayer. And today's chaplain is Chaplain Major Keith Beckwith with the Minnesota National Guard. As a gentle reminder, following the prayer, please remain standing for the Pledge of Allegiance.
I encourage you to pray in your tradition as I pray in mine. Heavenly Father, we gather here today in this esteemed chamber. I seek your wisdom and guidance. We thank you for the privilege of serving the people of Minnesota and for the opportunity to come together in pursuit of this common good. I pray that we grant all here clarity of thought and unity of purpose as they deliberate on matters that affect our communities and our state. May their decisions be rooted in respect, understanding, and a commitment to justice, from here in the legislative epicenter of the capital of Minnesota to the smallest township. Help them to listen to one another with open hearts and to approach their work with humility and integrity. I pray they are inspired by the needs of their constituents and strive to create a brighter future for every Minnesotan. Finally, I ask your blessing upon the decisions they will make today and for future decisions and actions they will decide, consider, and determine. May they reflect the values of compassion, impartiality, and service. In your holy name, I pray. Amen.
Thank you. I will now ask Senator-elect Heintzeman from the 6th District to come forward and subscribe to the oath as administered by the Honorable Paul C. Thiessen, Associate Justice of the Supreme Court.
If you'd raise your right hand. Do you solemnly swear to support the Constitution of the United States and the Constitution of the State of Minnesota, and to discharge faithfully your duties as a senator to the best of your judgment and ability, so help you God?
I do.
All right, congratulations.
Thank you.
Welcome. That's it. You can clap if you want.
Thank you, members, and welcome to the new senator. The secretary will take the roll.
Abler, Anderson, Barr, Bolden, Carlson, Champion, Clark, Coleman, Swadzinski, Dames, Dibble, Dornick, Draheim, Drazkowski, Duckworth, Farnsworth, Fateh, Frentz, Green, Grunhagen, Gustafson, Hoschild, Herr, Heintzeman, Hoffman, Housley, Howe, Jasinski, Johnson, Johnson-Stewart, Klein, Curran, Kroon, Kunish, Kupek, Lang, Latz, Liskey, Limmer, Lucero, Mann, Marty, Matthews, May Quaid, McEwen, Miller, Mitchell, Mohammed, Murphy, Nelson, Umu Verbatim, Pappas, Pa, Port, Pratt, Putnam, Rarick, Rasmussen, Rest, Seeberger, Utke, Weber, Wiesenberg, Westland, Westrom, Wickland, Zhang.
Members, a quorum is present. The following members intend to vote from a remote location pursuant to Rule 40.7, Senator Farnsworth, Senator Port, and Senator Lang. Members, if you want to follow along, I'm reading from our Senate agenda dated Tuesday, May 6, 2025. We will begin at the third order of business. Messages from the House. The Secretary will read the first message.
Mr. President, I have the honor to announce the passage by the House of the following Senate file as amended by the House, in which amendments the concurrence of the Senate is respectfully requested. Senate File Number 2077, a bill for an act relating to state government, appropriating money for environment and natural resources, appropriating money from Environment and Natural Resources Trust Fund. Senate File Number 2077 is herewith returned to the Senate. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
He's right here. Standing right there talking to Senator Tom.
Senator Herr? Senator Herr, for a motion.
Thank you, Mr. President. I move that the Senate do not concur in the amendment by the House Senate File number 2077, and that a conferring committee of 5 members be appointed by the subcommittee of conference committees on the part of the Senate to act with a like conference committee appointed on the part of the House.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. The Secretary will read the next message.
Mr. President, I have the honor to announce the passage by the House of the following Senate file, as amended by the House, in which amendments the concurrence of the Senate is respectfully requested. Senate File Number 2370, a bill for an act relating to cannabis. Senate File Number 2370 is herewith returned to the Senate. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
Senator Dibble for a motion.
Thank you, Mr. President. I move that the Senate do not concur in the amendments by the House to Senate File Number 2370, and that a conference committee of 3 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed on the part of the House.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. The Secretary will read the next message.
Mr. President, I have the honor to announce that the House has acceded to the request to the Senate for the appointment of a conference committee consisting of 4 members of the House on the amendments adopted by the House to the following Senate file. Senate File Number 2216, a bill for an act relating to commerce, establishing a budget for the Department of Commerce. There has been appointed as such committee on the part of the House Herr, Elkins, O'Driscoll, and Reimer. Senate File Number 2216 is herewith returned to the Senate. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
No action required. The Secretary will read the next message.
Mr. President, I have the honor to announce that the House refuses to concur in the Senate amendments to House File Number 2432. House File Number 2432, a bill for an act relating to state government, providing for judiciary, public safety, corrections, and government data practices policy. The House respectfully requests that a conference committee of 4 members be appointed thereon. Novotny, Mueller, Scott, and Liebling have been appointed as such committee on the part of the House. House File Number 2432 is herewith transmitted to the Senate with a request that the Senate appoint a like committee. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
Senator Murphy for a motion on behalf of Senator Latz.
Thank you, Mr. President. On behalf of Senator Latz, I move that the Senate accede to the request of the House for a conference committee on House File 2432, and that a conference committee of 5 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed by the House.
To that motion, all in favor say aye. All those opposed say no. The motion prevails. The Secretary will read the next message.
Mr. President, I have the honor to announce that the House refuses to concur in the Senate amendments to House File Number 2446. House File Number 2446, a bill for an act relating to state government, establishing a budget for the Department of Agriculture, the Board of Animal Health, the Agricultural Utilization Research Institute, and the Office of Broadband Development. The House respectfully requests that a conference committee of 6 members be appointed thereon. Anderson, P.H., Hansen, R., Harder, Smith, Burkle, and Gottfried have been appointed as such committee on the part of the House. House File Number 2446 is herewith transmitted to the Senate with a request that the Senate appoint a like committee. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
Senator Putnam for a motion.
Thank you, Mr. President. I move that the Senate accede to the request of the House for a conference committee on House File Number 2446, and that a conference committee of 3 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed on the part of the House.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. The Secretary will read the next message.
Mr. President, I have the honor to announce that the House refuses to concur in the Senate amendments to House File Number 2431. House File Number 2431, a bill for an act relating to higher education, providing funding and policy-related changes for the Office of Higher Education, Minnesota State Colleges and Universities, and the University of Minnesota. The House respectfully requests that a conference committee of 4 members be appointed thereon. Wolgamott, Rarick, Robbins, and Coulter have been appointed as such committee on the part of the House. House File Number 2431 is herewith transmitted to the Senate with a request that the Senate appoint a like committee. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
Senator Fate for a motion.
Thank you, Mr. President. I move that the Senate accede to the request of the House for a conference committee on HF number 2431, and that a conference committee of 3 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed on the part of the House.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. The Secretary will read the next message.
Mr. President, I have the honor to announce that the House refuses to concur in the Senate amendments to House File Number 2438. House File Number 2438, a bill for an act relating to transportation. The House respectfully requests that a conference committee of 4 members be appointed thereon. Kosnick, Olson, Cagle, and Tabke have been appointed as such committee on the part of the House. House File Number 2438 is herewith transmitted to the Senate with a request that the Senate appoint a like committee. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
Senator Dibble for a motion.
Thank you, Mr. President. I move that the Senate accede to the request of the House for a conference committee on House File 2438, and that a conference committee of 5 members be appointed by the Subcommittee on Conference Committees on the part of the Senate to act with a like conference committee appointed on the part of the House.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. Members will now proceed to the 5th order of business, which is the reports of committees. Senator Murphy for a motion to adopt committee reports.
Thank you, Mr. President. I move committee reports printed in the agenda be adopted.
On the adoption of committee reports, all in favor say aye. All those opposed say no. The motion prevails. Members, we will now proceed to the 7th order of business, which is second reading of House bills. The Secretary will read the House file numbers.
House File Numbers 2130, 2115, and 2434.
The House files have been given their second reading. We will now move to the 8th order of business, which is introduction of first readings of Senate bills. The bills listed on today's introduction calendar are given their first reading and referred as indicated. We will now move to the 9th order of business, which is motions and resolutions. We will adopt the author's motions as one motion. All in favor say aye. All those opposed say no. The motion prevails. Senator Abler for a motion.
Well, thank you, Mr. President. I move that Senate File 3330 be withdrawn from the Committee on Health and Human Services and be returned to author. It's just not ready for prime time. Thank you, Mr. President.
On that motion, all in favor say aye. All opposed say no. The motion prevails. Senator Howell.
Thank you, Mr. President. Pursuant to Rule 5.1, I move that House File 1290 be withdrawn from the Committee on State and Local Government, given a second reading, and placed on general orders. Mr. President, this bill is, it has to do with AED signage. It is sitting in state and local government. I've talked to the chair of the committee. He is good with this. It passed the other body unanimously.
Senator Howell, thank you so very much. Any other discussion on Senator Howell's motion? Senator Young.
Thank you, Mr. President. I have talked with the author on this, and I would encourage a yes vote. Thank you.
Okay, on the Howell motion, all in favor say aye. All those opposed say no. The motion prevails. Second reading of House File 1290.
House File number 1290.
House File 1290 has been given its second reading. Senate Resolution number 38 will be referred to the Committee on Rules and Administration. No action is required there, members. Remaining under motions and resolutions, Senator Murphy for a motion to designate special orders.
Thank you, Mr. President. Pursuant to Rule 26, I designate the following bills be made special orders for immediate consideration. Members, the list is on your desk.
Members, the list is on your desk. We will start with Senate File number 1750. Senator Lucero.
Thank you, Mr. President. I would begin, before giving remarks, like to offer the A15.
Senator Lucero offers the A15 amendment. The Secretary will report the A15 amendment.
Senator Lucero moves to amend Senate File number 1750 as follows. Delete everything after the enacting clause and insert. This is the A15 amendment.
Senator Lucero, to your A15 amendment.
Thank you, Mr. President, and thank you, members. Senate File 1750 is the Homeowners Association and Common Interest Community Reform Package. The A15 is the delete all amendment that represents the changes and the updates that we've made since the bill's first introduction. But before I go there, I want to give a little bit of background. Mr. President and members, last year, this legislature passed a provision that formed a legislative work group on common interest communities and homeowners associations. And that work group consisted of 20 members. One member from each of the caucus in each of the bodies, so that was 4 of the 20, and then the other 16 members represented a broad cross-section of industries that were directly related to common interest communities and homeowners associations. And that included a representative from the League of Minnesota Cities, a representative from the Minnesota Home Ownership Center, a representative from Common Associations Institute, which is CAI, a representative from a business association that supports, educates, or provides services to CICs and HOAs, designated by the Commissioner of the Department of Commerce, one representative from Legal Aid, one representative from the Minnesota Association of Realtors, one representative who's an attorney and regularly works advising homeowners and residents on CICs and HOAs, and is familiar with state foreclosure laws, and the appointee is designated by the Minnesota Bar Association. one designee who is an attorney and regularly works advising CIC and HOA boards designated by the State Bar Association, one designee from the Minnesota Housing Finance Agency, one designee by the Attorney General's Office, one designee by North Country Cooperative Foundation, one designee by Senior Housing Cooperative Council, and 4 designees by Housing Justice Center. Mr. President, I say that because it's important to know that those discussions on the work group represented, again, this broad cross-section. We began meeting in September of last year. We met 14 times and had many, many conversations. We had presentations from different experts in different topic areas. We had testimony from the public. In addition to those 14 meetings, we had 3 meetings in communities in the evenings, giving direct access to residents from around the metro to come in and give testimony and feedback on homeowners associations and CICs. The product then of these meetings was a report that was given to the legislature here in February 1st of this year, and it contained approximately 100 recommendations. Of those 100, 41 of those were primary recommendations. That report then passed out of that broad cross-section of the work group with unanimous support. Unanimous support. That report then resulted in the legislation that was introduced in 1750, but the conversations continued. We met with many, many stakeholders. And when I say I'm referring to the bipartisan coalition that is myself, Senator Pah, Representative Bonner in the other body, and Representative Mecklin in the other body. We had this coalition, the 4 of us, meeting on a regular basis, receiving hundreds of communications of feedback on recommendations to include for reform, changes to the bill, and it included hundreds of hours of time that resulted in this, what we have before us, the A15. So just highlighting then some of the provisions that are in this bill or amendment. It will require an association to provide a schedule of fees and charges. It removes authority to impose interest on late payments. It prohibits an association from imposing a late fee for a payment of assessments that in excess of $15 or 5%, whatever is greater. It requires a notice and opportunity to be heard before an association imposes a fine. The amendment prohibits the association from charging attorney's fees and costs to unit owners who simply ask a question about a fine or assessment. It prohibits associations from imposing charges, including attorney's fees, for responding to a question about a governing document or any aspect of the operations or management. It requires associations to provide a 60-day notice of a board's intention to change a rule. A rule may be revoked by a majority of the total in the association. It requires an association to adopt procedures for dispute resolution. A payment made by a unit owner must be applied to the regular assessment first before being applied to fines and fees. It requires that elections for board officers occur regularly and in accordance with their governing documents, not to exceed 3-year term. Requires that board meetings of directors be open to the unit owners. It requires that reasonable notice be given to unit owners of a board's agenda. The conflict of interest that is required of officers of the association. It prohibits a board member from participating in deliberations or a vote on the approval of a conflict where the board member or their family has a material financial interest, which is likely to result in a financial gain. It prohibits a board member or management company from soliciting or accepting money or other compensation from a person as an inducement for a board member or management company. In other words, it prohibits bribes. It requires that a board or management company to solicit at least 3 written competitive bids for contracts for property management, construction, repair, or reconstruction when the cost is estimated to exceed $50,000. And there are exceptions to this competitive bid if there are multiple bids cannot be obtained, if an emergency repair is required to protect the health or safety, if there is significant damage to the property that must be addressed without delay, if the work is covered by a warranty, if there is only one vendor that is capable of providing the goods or services. It provides that a management company may not require an association to work with a particular vendor. It requires a meeting notice to include copies or links of any documents that are subject to discussion or approval at the annual meeting. It requires the association to provide each unit owner with a copy of the proposed annual budget prior to the annual meeting at which the budget is to be approved, and allow unit owners to provide input on the budget prior to or during the meeting. It has provision that the association may not begin foreclosure proceedings for delinquent payment of assessments unless the total amount of the unpaid assessments and all types of other assessments exceeds $1,500 and is outstanding for at least 120 days. If the monthly assessment is less than $500, or it allows for $2,500 if the assessment is greater than $500. It requires an association to engage in an informal dispute resolution process upon a unit owner's request. Before referring an inquiry from a unit owner to an attorney, the board must provide the unit owner at no cost to the owner a statement that the board plans to refer the matter to an attorney, the name of the person responsible for payment of the resulting legal fees, and an hourly rate of the attorney, and provides that the association may not retaliate against the unit owner for asserting any right that the unit owner has under the chapter of law. Mr. President, those are some of the highlights of the amendment. I'm looking forward to the discussion. This is a pro-consumer bill. It is a bill that brings transparency and accountability. It ends the conflict of interest. It allows for residents to be involved with, again, knowing the agenda and being able to give input. And there are many, many positive things in this long overdue reform. And with that, Mr. President, I would like to yield to Senator Pah.
Thank you, members. We don't yield, but I'll be happy to go to Senator Pah. Senator Pah, we're on the A15 delete all Lucero amendment. Senator Pah.
Thank you, Mr. President, and thank you, Senator Lucero, for speaking to the bill in such detail. I rise in support and to speak a little bit about this bill. Across our state, HOAs operate with very minimal regulations, often wielding more authority than local governments. They can impose fines, enforce foreclosure, dictate community standards without accountability. This bill has been extensively and carefully revised to address everyone who have expressed input and concerns, that is legislators, our colleagues here and in the House, lobbyists, stakeholders, HOAs, board members, homeowners. All that we have heard from, we have made an effort in working with them on the bill language, making sure that this bill is ready to implement and that would be good for Minnesotans. Senator Lucero had already talked about all the different groups and stakeholders who are a part of this, so I won't go over that again. But just know that this bill has been vetted, has been worked on, and literally have hundreds of compromises and changes to make sure that this bill is something that's good for Minnesota. Right now, there is a glaring gap in our laws that leave tens of thousands of homeowners vulnerable. The gap is a total lack of, honestly, meaningful state oversight of homeowners associations and CICs. Over the last 8 years, we have seen alarming numbers of incidents, and it reveals just how unchecked HOAs truly are. And while local governments are often blamed for inaction, the truth is they have no power over HOAs. The state has to put in laws that have oversight over HOAs. Without safeguards, good intentions are not good enough. Power without accountability always opens the door to abuse, the abuses that we have heard and seen in our state, and the stories that have come out in the news are proof of just that. Members, I encourage you to please support this bill. Failing to act would be reckless. It would mean turning our backs on the growing number of Minnesotans who would be harmed if we did nothing. Again, people are losing their homes to sometimes small fees and fines. There was one story in recent years where a homeowner was in foreclosure for $56. No one should have to go through that. Thank you, members. Thank you, Mr. President.
Senator Latz.
Mr. President, members, I recognize and appreciate the work that Senators Lucero and Pa have done in this space. I think we probably all have stories we've heard about concerns in the manner in which HOAs have conducted their business, and in some cases excessively or unfairly. And I recognize and appreciate the work that the task force did. It's a lot of work. It's a lot of work to put together major changes to existing regulations of common interest ownership operations under the MCIO, or the Minnesota Common Interest Ownership Act. That original act was based upon statutes proposed by the Uniform Law Commission, which is a national body that's vetted nationally with some of the top reviewers in the country, lawyers. Through the Bar Association, Minnesota has our own appointees to that commission. And so it is true that currently there are substantial regulations on the books, on the state statutes, for HOAs and common interest ownership communities. And in fact, the State Bar Association has their own subcommittee that is membership by lawyers who represent parties in all different aspects of this. The HOAs, the owners of the property, all sorts of other stakeholders, developers, and so on. This is a fairly complicated bill, which does not represent a consensus of all the stakeholders. It has a lot of good things that it seeks to do, and someday I would like to see that those become law. However, what you have before us here today, I'm not sure if it's unprecedented, but it's quite unusual, is a 54-page delete everything amendment that's being proposed here for the Senate to consider. This is the kind of normal thing we would see in committees, a delete everything amendment that represents perhaps a stakeholder consensus, but that's not what we have here today. What we have instead is a 54-page delete everything amendment that we're being asked to consider today. And that delete everything amendment contains quite a number of substantial changes since the bill left the Judiciary Committee on a divided voice vote. I've got 2 pages here, a listing of what those proposed changes are. One of them creates terminates a first mortgagee rights by default, a default, if the mortgagee doesn't respond within 60 days of a notice of termination, regardless of what the mortgage documents require. So this would override existing mortgage documents. It contains major revisions to the conflict of interest provision and doesn't address any remedy for a breach or for a low bidder that's unsuccessful. It removes certain notice requirements. It has a major revision to a new dispute resolution process. It changes thresholds for HOA assessment actions. Members, what you have before you is pretty substantial proposals. Now, I have to tell you that although the proposal came out of the task force, apparently only one vote was allowed in that task force. The lawyers that were on the task force wanted to deal with proposals individually, one by one, so they could look at them, vet them, and make decisions as a task force that way. But that request was denied in the task force. It was only brought up to a one vote up or down proposal. The bill or the amendment that you have before you, the Delete Everything Amendment, contains potentially unconstitutional terms that would impair contracts, existing contracts, as well. Members, I've got a 14-page memo in front of me that was drafted by the chair of the State Bar Association MCIO subcommittee after discussion with the subcommittee's members to provide technical feedback on the proposal that came out of the task force. Actually, it was drafted initially to Senate File 1750 as it was introduced and then updated following an amendment in the other body. 14 pages here. I'm told only a few of the technical suggestions have been adopted by the bill's authors. As much as I would like to say that we are ready to vote on this, that we are ready to put this into law, I'm afraid to conclude that we're not. We're not. This floor is now being asked to do the work of the Judiciary Committee on probably 20 or more major changes to the proposal since the bill left the Judiciary Committee in this body. I think it's very, very important when we pass bills here in the State Senate that the bills be ready to become law, not only as a matter of policy, but as close as possible as a matter of technical drafting. There is no guarantee that there will be changes in the process after it leaves this floor that would fix all of the technical drafting defects in this proposal, let alone try to reach further agreement or consensus among stakeholders. Members, I regret to say I just think we're not ready to take a substantive vote on this bill. So with that said, I think the Judiciary Committee needs to take another look at this, work through it, and if it comes back here, it comes back with a solid set of drafting as well as recommendations on the proposals before us. So with that, I move that Senate File 1750, number 26 on general orders, be stricken and re-referred to the Committee on Judiciary and Public Safety, and I ask for a roll call.
Roll call requested, roll call granted. The motion before the body is pursuant to Rule 32, motion to refer. Senator Latz has moved and put forth the motion for this bill, which is Senate File 1750, to be returned or referred to the Judiciary Committee. Any discussions on that motion? Senator Kroon.
Thank you, Mr. President. I rise in support of Senator Latz's motion to send this bill back to the Judiciary Committee. I do appreciate the work that the authors have done on this, including some of the discussion that we did have in Judiciary Committee and the many amendments that have been made to the bill in an attempt to make it better, including some of the issues that we discussed in Judiciary Committee. But, Mr. President, the fact remains that there are still many technical problems with this bill. There's many substantive policy considerations that I don't think have been addressed, have not involved all the relevant stakeholders. This is a very important area of the law, a very technical area of the law, and so I think it's not ready for a floor vote. I think we need to send this bill back to the Judiciary Committee. I just am looking at the A15 amendment for the first time now. I had a slightly similar version that I got yesterday that I've been trying to put amendments together to try to make it better, and I've come to the conclusion that we just don't have enough time to make some of those happen. I'll just briefly say, Mr. President, high level on this bill, the retroactivity provision here is problematic from my perspective. When MKIWA, or the Minnesota Common Interest Ownership Act, was enacted in 1994, it was not a retroactive application. It was for associations that were formed after the effective date, or for those associations that wanted to opt in to that new provision. I think that is a better way to approach this, because there's problems that arise when you start having it apply retroactively, which is why we need to be very careful if we're going to have a retroactive effective date. Senator Latz talked about how it can impair contract rights. That's very true, and it does potentially raise constitutionality questions with the bill. And so that is a serious problem. The mortgage provision that Senator Latz cited is also very serious. When you go from 80% to 60% to terminate a CIC, that does make it easier to terminate, but also it makes the rights that the mortgage holders have more precarious, if you will. And we're overriding mortgage document provisions. I'm not sure how having the implied consent by estoppel provision, whereas if a mortgage company doesn't get back to the notice of termination within 60 days, it is presumed that they agree with it and that it's essentially a yes vote. I have problems with that. I don't know how that affects securitization of the mortgages or Fannie Mae provisions, those sort of things. I'm not sure if the Bankers Association has thoroughly vetted it. I have not had a chance to talk to the Bankers Association about that, but there could be several unintended consequences of this provision. Also, the conflict of interest provision, I think, is a substantive policy thing that really we should be bringing attention to. It's essentially a prohibition on contract, and that I think would be better dealt with through disclosures of conflict of interest rather than prohibitions. There are several good reasons to not have to go out for a bid on some of these matters, that a disclosure would be sufficient. There's many more I could go into. I think, Mr. President, that on a bill this technical, it would be helpful to engage the Bar Association in addition to the other stakeholders that were on the task force to make sure that this bill is workable when we have when it passes and have a finished product. And I think for those reasons, Mr. President, I would support Senator Latz's motion to send this bill back to the Judiciary Committee. Thank you.
Senator Parr.
Thank you, Mr. President. So I rise in opposition to sending this back to the Judiciary Committee. This bill has already gone to the Judiciary Committee, in which Senator Kroon has given us raised up some concerns and some suggested language for amendment, which is in this DE amendment. And so we've had a robust conversation in Judiciary, taken people's concerns and their suggestions, put that into this amendment. That is why today we have this DE, just to make it simple, so that all the amendments that we need to include are in here versus making small amendments on a separate amendment and not as a DE. I know there was conversation about having the Minnesota State Bar Association input on this, but I just want to make sure that I let members know that the Minnesota State Bar Association has been working with us very closely on this bill. I have a document here that has 15 changes that we've made in compromise to the Minnesota State Bar Association. They've looked at our bill. They've given us suggestions and input. We've taken that. Whether they were in the first bill or the second engrossment or this DE, we have continued to have those conversations. They have not raised a concern to me in the last few weeks that we have been aware of. So if there is ongoing concern since the last time I spoke with them, I'm not aware of any. The conflict of interest that Senator Kroon spoke about, I just want to clarify that it does not prohibit contracts. It just requires disclosure. I think we can all agree that you must disclose a conflict of interest, especially if you have a financial benefit, whether you're a board member or a property management company. It does not prohibit contracting. So I just want to clarify that for Senator Kroon and for members. The mortgage 60 days consent, default of consent with 60 days for mortgagees in banks. We have been talking with the Minnesota Bankers Association, and they have not raised a concern about that. They know that language is in there. They haven't said that was a concern. They did give us a list of other things that they didn't like. That wasn't one of them. That was also the Minnesota Unions Network, Credit Unions Network. We have not heard from them that they're opposed to that 60 days. So I just want to address those two things. There have been a lot of conversations, ongoing work with many stakeholders. We have been open to everyone who has had a concern and been working with them to address those concerns. And so, Mr. President and members, I hope that you will support this bill, and we do not want to see it go back to Judiciary Committee. We've already been there, and we've already had a robust discussion. Thank you.
Senator Pappas.
Thank you, Mr. President, and I rise very reluctantly to support the motion. We desperately need this bill. I live in an HOA, and I know how important it is to have these protections and these guardrails. But frankly, in all my years here, I've never seen a 54-page delete all amendment on the floor of the Senate. I mean, this can happen in committee, and often it does, and that's kind of can be disconcerting, but in committee, you have time to go through each provision to discuss which has been reviewed by which committees, what are the new provisions, why are they changed. You have the stakeholders that can testify as to why this is a good idea, why it's not a good idea. We don't have stakeholders here on the floor of the Senate. We just have us. And this is a very important and complicated bill, and I really, really appreciate all the work that's gone into this. So that's why I am so reluctant, but I just feel like we have to make it right, and I'm sorry this is coming before us so late in session, but better to get it right the first time. And still, I'm sure we'll still be coming back and making amendments, but this is just really over the top to have this large and substantial an amendment on the floor of the Senate.
Any other discussion on the motion to re-refer before we go to Senator Lucero, and then the last voice that we'll hear is that of Senator Latz. Any other discussions before those two individuals? Senator Westrom.
Mr. President, wondering if Senator Latz would yield for a question.
Senator Latz, will you yield for a question? He will yield for a question. Senator Westrom.
Senator Latz, what would your schedule be and what would your intention be on this bill if it was in your committee? when you could look at it and when it would get turned around, because I'd be concerned that maybe we'd run out of time rather than fixing it on the floor or changing it on the floor. That's done all the time around here, and we as a full body have the authority, and this is the original jurisdiction and the original place that any bill passes. So it's just the committee is kind of a helpful process, but it isn't the only process. So I'm just wondering what your plans would be, or is the intention to just get it there and in your way of trying to kill it?
Senator Latz, to the question provided by Senator Westrom.
Mr. President, Senator Westrom, I am not trying to kill this bill. I think there's some good stuff in it. I think it's important that it be passed. But I think it's got to be passed with the right language in it, because we're making state law. I mean, it's hard to go back and change state law, as we all know. And in this highly technical area, real estate law especially, and real estate lawyers have known this. We've seen this. Usually when we get real estate-related bills, they come to us having gone through the real estate section of the State Bar Association, and we have the chair of that section, or the relevant subcommittee, would be in this case MCIO, come and testify that they've reviewed all the language, they've met all the needs, and it's clear to all the practitioners so they know how to implement it. That hasn't happened here. I'm sorry, but that's just a big deficiency. Now, in terms of schedule, time permitting, I would love to have, I'll call the Judiciary Committee together to work on this if we got time in the next 2 weeks. And let's be candid, we may very well not be done with all the work that we need to do this year by May 19th, which is less than 2 weeks away. So there, frankly, might be time in June with a special session, if we go there, to still be able to try to reach a consensus that technically works and address these things on the merits. I'm happy to put the time in as the chair of the Judiciary Committee to facilitate that. So I'm not at all trying to kill the bill. I just want to make sure what we do right.
Senator Westrom.
And Mr. President, thank you, Senator Latz. I guess that's some of what I'm trying to evaluate here. I'd be open to what other people think, because I think there is a need, as excuse me, as Senator Pappas mentioned, there's a pent-up demand to do something, and I want to help get it right also. So I appreciate the efforts that have gone into this by Senator Lucero and Paul and others. So I'm a little on the fence of which way to go here to best get this done. Albeit a 54-page amendment is not that big, and it's not that uncommon on this Senate floor. Oftentimes there's delete all amendments of omnibus bills that are hundreds of pages, and so I think we should just correct the record. Last year, I think at the end of session, there was an over a 1,400-page amendment that wasn't even available to members. So that has been precedent, and certainly 54 pages is much, much, much smaller than some of the big bills that have been amended last minute as well. So I think we are capable as a Senate to have an amendment here in front of us, time in caucuses to review this with staff, and we could get it done here on the floor, and that might be the most efficient way to do it.
Senator Marty.
Thank you, Mr. President. I'd like to speak against the motion to send it back, not because I don't think committees have a very important role and judiciary has a critically important role, and not because they've heard it once, but because the work that's been done since then. I've been watching from a distance to Senator Lucero and Senator Paz's work on this and the task force involved. I was working on a separate HOA bill, the HOA ombudsperson bill. But I've just seen how they've been bringing everybody in. It's truly been what we want people to do, where they bring in all the parties involved and they try and work out the differences. And I think the differences that have occurred in the last, that's in this delete all amendment, have been ones that have reflected that. They've been trying to hear from not just the homeowners, not just the big HOAs, but the little ones, HOA management companies. They've had so many different groups, not just the Bar Association, but legal aid, and Senate staff trying to work with them, House staff, I believe, too, trying to put together a very complex problem with very urgent problems. Some of the horror stories we've been hearing in the media, they're not across the board, but they do happen. And I think we really want to get this done. And I don't think we should do it by cutting corners, but I don't know that this is cutting corners, because Senator Latz, after your committee, the work that's been done has been done by the same people who've been working all summer, all fall, all winter to try and put together a bill. And I just think that the work that's been done since then has been trying to address the outstanding concerns that were there after your committee. Again, not to diminish the importance of your committee, but I think that the work that's been done since then has actually been following up on trying to address those concerns. And there won't ever be peace on the Valley on something like this. There's some who are never going to be 100% concerned. But I got to say that this team of the 2 senators and the 2 House members and all of the members of the task force have been doing incredible work on a very difficult issue. And it's a very comprehensive bill. I wouldn't do everything exactly the same way. None of us would. But I think the way they put it together gives a good step forward for the state and for all the folks doing this, and I urgently hope we can get this done this year. I urge you not to send it back, but I say that reluctantly because I understand how good committee work can be. I just think the work since then has been improving it.
Any other discussions before I go to Senator Lucero? Senator Drazkowski.
Thank you, Mr. President. Members, just briefly, if we send this back to committee, it will stay in committee and it will not be coming back before the end of session. We have got conference committee reports all next week. We've got other budget bills to deal with and other competing bills. It's not realistic to believe that this would come back before us here. I'd encourage a no vote on the referral, and instead let's trust the process. There's another body over there that is going to have their ideas that they bring forward, and more discussion will happen with this outstanding effort, I think, that has happened amongst a bipartisan, bicameral group attacking really a very important area of law here. Thank you, Mr. President.
We'll now go to Senator Lucero, and then Senator Latz will be the last voice we'll hear before we take the vote. Senator Lucero.
Thank you, Mr. President, and thank you, members. Thank you, Senator Latz. Thank you, Senator Kroon. Thank you, Senator Pappas. Thank you, Senator Marty, Senator Paz, Senator Drazkowski, and everybody else who is been receiving information on this, has thoughts on this, but the time is now. It is not that this is not ready to become law. It's that when discussing these very important concepts of conflicts of interest, of excessive fines in fees, of lack of transparency, consumer protection, dispute resolution, and on, it's not that it's not ready, it's that you have to draw the line somewhere on each of these issues. And no matter where the line is drawn, there will be people that seek to move the line. And that's what's at issue here. I appreciate the feedback. We have been very deliberatively collaborative, open, receiving all feedback with willingness and readiness to do the best we can. But there will be points where we just have disagreement on where that line is drawn. That is not a reason to send it back to committee. It's a reason to move forward, recognizing there will never be a consensus when you draw the line of lack of transparency or when you prohibit conflicts of interest. Somebody will not be happy with that. So members, Mr. President, members, I sincerely encourage a no vote. We've been working on this for 6+ months. Hundreds of hours, hundreds of feedback and communication. We no longer need to go back to committee. Thank you.
Senator Latz for the last words we hear before we vote on the motion to re-refer.
Thank you, Mr. President, members. And I will say again, I appreciate the work that Senator Lucero and Senator Paz and many others have put into this. But there's a reason that we have the process that we have. And our process in the Senate does not depend on what kind of job or whether the other body does anything over there. Our job in the Senate is to do it right here in the Senate. When it left the Senate Judiciary Committee, it had quite a few issues still remaining with it, and the committee decided to give it some time. But what's happened since then is basically the work of the Judiciary Committee has been subsumed by the others involved in negotiating over these provisions. The language, however, still needs work. We could spend 4 hours or 5 hours on the floor and work technically through line by line on this bill, but that's not the way this process is supposed to work. And we might not even end up at the right place because, as Senator Pappas pointed out, we don't have the input from the stakeholders here on the floor. We don't have the input from the fly-speckers that need to fly-spec real estate law in Minnesota. There have been so many changes now that have come before us. These aren't tweaks. These are substantive changes. And yes, we do have situations where bigger bills come before us, typically omnibus budget bills or conference committee reports. But that's not what we have before us here today either. We've got a 54-page delete everything amendment with highly technical language that still needs a lot of work if it's going to work right if and when it becomes law. That's our job here. And we're not able to do that well here on the Senate floor. I've already indicated I will find the time to convene a Judiciary Committee if there's any possibility of doing that, and the stakeholders can convene and we can take further input. I don't think it's a matter of running out of time. I think it's a matter of doing the job right. And right now, this needs to be done in committee, in the Judiciary Committee in particular. Appreciate your support for the motion.
The Secretary will take the roll on the motion to re-refer. Members, please vote. Pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Umu Verbatim votes no.
Senator Umu Verbatim votes no.
Senator Fate votes no.
Senator Fate votes no.
And Senator Murphy votes no.
And Senator Murphy votes no. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Farnsworth votes no.
And Senator Farnsworth votes no. All senators having voted who desires to vote, the Secretary will close the roll. There have been 26 ayes and 41 noes. The motion to re-refer is not adopted or fails. Members, we are now back on the A15 amendment. Senator Draheim. Oh, I think he had a motion. Senator Rasmussen.
Thank you, Mr. President. I'd like to offer the A19.
Is this an amendment to the amendment?
Yes, Mr. President.
Senator Rasmussen offers the A19, which is an amendment to the amendment. The Secretary will report. So, Senator Rasmussen, we have a concern that it's not drafted to the amendment. We're going to double check that, okay?
This is the A19 drafted to the A15. Oh, so it needs to, you did tell me this. We need to adopt. Okay. Everybody 10 times. Got it. Thank you. Okay, bye.
Senator Rasmussen, all of the amendments have been drafted to the A15 as if it has been adopted. Currently, the A15 has not been adopted, so it would be inappropriate to take your amendment at this particular time. So once it is adopted, then we can revisit it. Senator Rasmussen.
Thank you, Mr. President. I'll withdraw the A19 and offer it after we've adopted it.
The A19 has been withdrawn. Members, we're on the A15 Lucero amendment. Any other discussion? Did you want to make any last minute words? Okay. Seeing no further discussion, all in favor say aye. Aye. We're pointing, who are we pointing to?
You took the vote.
So we've already started taking the vote, so I can't do it now. All in favor say aye. Aye. All those opposed say no. The motion prevails. The A15 is adopted. Senator Rasmussen.
Thank you, Mr. President. I would like to offer the A19.
Senator Rasmussen offers the A19 amendment. The Secretary will report the A19 amendment.
Senator Rasmussen moves to amend the Lucero A15 amendment to Senate File Number 1750 as follows. Page 54, after line 9, insert. This is the A19 amendment to the A15 amendment.
Senator Rasmussen, to your A19 amendment.
Thank you, Mr. President. I would request a roll call.
Roll call requested, roll call granted.
Thank you, Mr. President. One problem that Minnesota has with HOAs is that some local units of government require them as a condition to build more housing. And this can sometimes unfairly push infrastructure costs onto new development, driving up the cost of home ownership for Minnesotans, driving up the cost of rent for Minnesotans. And so, Mr. President, we've also seen an example in one locality where a city has effectively banned residents from owning their own front yard. They require two different lots, one where the home is placed, and then an outlot that is owned by the HOA. And so we have local units of government that are effectively banning Minnesotans from owning their front yard in order to get a building permit. So the A19 amendment would prohibit local units of government from requiring an HOA when it is not required by state or federal law or rule, or when there is a common element that the local government would like to be maintained or insured. This, Mr. President, I want to be clear. If a developer wants to set up an HOA, they'll be able to set up an HOA, and they'll be able to do so if this becomes law. But a city can't come and require that they have an HOA as a condition of building new housing. Mr. President, I also had distributed letters of groups that support this amendment that's in front of you, including Housing First, which represents home builders across Minnesota, and then also the Say Yes to Homes Coalition, which includes everyone from Habitat for Humanity to Americans for Prosperity to Isaiah, to a whole list of folks that want to see more housing get built here in the state. And Mr. President, I also want to thank the League of Minnesota Cities and other cities who have provided feedback on this amendment. All feedback that has been provided from the League of Minnesota Cities is incorporated in the A19 in front of members, and they are neutral on this language. So I'd ask members for their support on this amendment. It will help make housing more affordable here in our state and take a small step towards improving this issue that we see.
Senator Lucero, do you have a comment on the A19 amendment?
Thank you, Mr. President. Thank you, Senator Rasmussen. I am in favor of this amendment I appreciate the remarks that Senator Rasmussen said. I'll just add the following. Among the many, many testimonies that we had and data to the work group, one statistic was very, very startling. Nationwide, approximately 79% of new developments are in HOAs. In Minnesota, that number, I believe, is more than 80% of new developments. That is a shocking number. And so this is seeking to address that number, and I appreciate the work that Senator Rasmussen has put into this, and others, Senator Port and others. I appreciate the conversations with the League of Minnesota Cities and other stakeholders to come up with this compromise language, and again, I am in support of it. Thank you.
Senator McQuaid.
Thank you, Mr. President, and I would like to speak in support of the Rasmussen A19 amendment. I think this is a good piece of policy. I happen to represent a city that currently requires new builds to be in HOAs, and we're getting to the point where if you want to buy a new house in Minnesota, particularly in the suburbs, you are forced to live in an HOA. It's not something that citizens are coming together and deciding to do. It is being thrusted upon them by city requirements. And so I think this is a really, really common sense, reasonable, easy piece of legislation for us to attach to the overall bill. I want to thank Senator Pah and Senator Lucero for all of their work on this issue with the numbers that we're talking about. 82% of new homes in Minnesota are part of an HOA. We're really getting to a point where we don't have a choice to put forward a bill like this. And so I speak in support of the Rasmussen A19, and I urge members to vote green.
Senator Pah.
Thank you, Mr. President, and thank you, Senator Rasmussen, for bringing forward this amendment. I don't know if we've asked for a roll call vote yet, Mr. President, so I'll go and ask.
A roll call has been requested and a roll call has been granted. Senator Pah.
Thank you, Mr. President. I strongly support this amendment. Members, I do ask for your vote green on this because this language will preempt cities from continuing to drive new developments into creating HOAs. It shifts, cities do this because it shifts the costs and responsibilities of long-term maintenance and amenity management away from the city and into private entities, primarily HOAs and its homeowners. HOAs have been used as a tool by cities to honestly privatize public-like services without adding to the city's responsibility and budget, and that is not acceptable. If communities want to be developed as an HOA and have amenities for people, that's great. But if cities are requiring certain amenities to be part of a conditional approval or an approval for development, that is not okay. Members, please vote yes. Thank you.
Senator Duckworth.
Thank you, Mr. President. I appreciate the opportunity to speak to this amendment. First and foremost, I want to put anybody at ease regarding this amendment. I've done a lot of work with the author of it. Appreciate the work he's done. I've talked with many of the cities I represent and other stakeholders to make suggestions and modifications to the language that's before us right now. But I would be remiss if I did not take an opportunity to make a couple of comments specific to cities and housing and things of that nature, because what I thought would happen, Mr. President, when it came to this amendment just happened. We heard a narrative that was strongly in opposition to or very critical of our cities, our local units of government, and how they've been operating as it relates to housing. And I think there's some important context that we all have to keep in mind, and I think there's more to that story that we should all be aware of, that the people of Minnesota should also be aware of as well. And also because throughout the conversation of this bill or amendment or others like it, there's been a lot of things said about a lot of our fine cities here in the state of Minnesota. Not all of it has been accurate. I happen to represent one of the fastest growing, largest cities in the state of Minnesota. And no, it's not Elko New Market, even though I love those guys. It happens to be the city of Lakeville. And during one of the hearings, someone said that the city of Lakeville would rather pay a fine to the Met Council than continue to develop or build more units. And that was simply just false. It obviously fired up the city, the administrators, the mayor. That person has been reached out to. But folks, we can't be, hopping on the bandwagon of what we think are popular narratives or political sound bites and taking shots at our cities and the people that are working hard on behalf of our residents inside our districts just because we think it's going to serve a point or maybe help something get passed. Oftentimes, you might have a city utilize a homeowner association agreement to take care of very valid business that needs to be handled and agreed to between that development and the folks that live there and the work that needs to be done, like snow removal, like the maintenance of other facilities, like how they're going to address a drainage pond or some wetlands. And so I appreciate the attempts made by the author of the amendment to ensure we're not going to have any issues regarding that in this amendment. But I'm telling you, Mr. President, there's a lot of fingers getting pointed at cities when people talk about the affordability crisis when it comes to housing. And what they forget is the circumstance that led to this situation. And that's that homes stopped being built for about a decade. Back in 2008, why? Mortgage fraud. Had nothing to do with our cities. As a matter of fact, many of our cities are the ones that helped to get us through that period of history here in our country, stepped in and actually took on some of those abandoned properties, fixed them, and made them available and livable so they're part of our housing inventory today. Because although we may have stopped building what would have been millions of housing units for 10 years, of course our population continued to grow. So that's the real issue. Mr. President, if we're going to have those conversations and we're going to partake in certain narratives, all I ask is that we be accurate, we be factual, and we focus on real issues like this amendment tries to do, rather than broad sweeping attempts to limit or completely revoke local control from the very people closest to the members that reside in our communities and those whom we represent, whose voices should be heard when it comes to their private property, where they live, their homes, their neighborhoods, and their communities. Thank you, Mr. President.
Senator Latz.
Mr. President, members, I'm looking at the language in the proposed amendment here, and on line 15, it prohibits the inclusion of any terms in an HOA declaration, bylaws, articles of incorporation, or other governing document. And on line 17, it prohibits requiring the adoption or revocation of or amendment to a rule or regulation governing the HOA or its members. Those are absolute terms that are extraordinarily broad. In fact, they take up the entire space. And actually, it's responsive to what Senator Duckworth just had to say, which is we can't, there's a lot that local governments do, and I served on a city council for 9 years, members, so I've been a part of it and I've seen it, that local governments want to do that may be important to be included in an HOA governing document if an HOA gets formed. And I'm concerned about that. Whether it has to do, I mean, cities require amenities in local developments all the time. And it may be that some of those amenities need to be addressed in any governing documents for an HOA. The way that paragraph 3 and paragraph 4 read, as I understand it, even if a developer says they want to have an HOA, the city still can't require the HOA governing documents to include any particular provisions. Members, I think this is a state-level intrusion on what ought to rightfully be local government authority, and whether that has to do with terms that affect garbage collection or snow removal or other things like that. I think it's important that if this is going to be written, that it be written in a way that reflects some discretion on the part of local government to tailor what they need in their community to the needs of that community. Because I don't think I can sit here right now and tell every community in the state of Minnesota what their particular needs are going to be, and sometimes that may include the need to have language in an HOA governing document. I'm not prepared to hogtie local government with supporting this amendment, so I'd oppose it.
Any other discussion before we go to the author of the amendment for the last word before we vote? Seeing no other discussion, Senator Rasmussen.
Thank you, Mr. President. And I just want to be clear that the amendment before the chamber, it allows for a lot of local control, but it does limit some of the local out of control that we've seen in the housing market. This amendment allows developers, individuals who want to get into an HOA to be able to get into an HOA. What the amendment does do is it makes it so that local units of government cannot force Minnesotans into an HOA. In the Senate Commerce Committee, which I serve on, we had really compelling testimony from a Minnesotan who came, and on her shirt, and I'm paraphrasing this, it said, "My city sold my rights to an HOA." And I think this is, if we're going to have this bill before the body be meaningful, we have to make sure that Minnesotans aren't being forced into a product that they don't want. If Minnesotans want to be a part of an HOA, great. They can become a part of an HOA and realize some of the benefits of it. But we shouldn't be requiring Minnesotans to not be able to own their front yard or requiring them to establish pickleball courts that they will have to maintain in perpetuity as a condition to get a permit. And that's what this amendment would address. And I want to be very clear that this amendment was created with deep input from cities. And every single suggestion that was offered by the League of Minnesota Cities has been incorporated into the amendment in front of you today, and that's why they're neutral. And I would also direct members' attention to the letters that are on your desk from Housing First, our home builders, from Americans for Prosperity, from Isaiah, from Habitat for Humanity. They all, AARP, they look at this as a positive step to allowing Minnesotans to have more housing options in their community, to help make housing more affordable across the state. And so I'd ask for member support of this common sense amendment that's going to have a positive impact on Minnesotans. Thank you, Mr. President.
The Secretary will take the roll on the A19 Rasmussen Amendment. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes aye.
Senator Port votes aye.
Senator Umu Verbatim votes aye.
Senator Umu Verbatim votes aye.
Senator Fate votes aye.
Senator Fate votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
And Senator Westland votes aye.
And Senator Westland votes aye. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Nelson votes aye.
Senator Nelson votes aye.
Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Lang votes aye.
Senator Lang votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There have been 58 ayes and 6 nays. The 819 Rasmussen Amendment is adopted. Senator Draheim.
Thank you, Mr. President. I'd like to offer the A17.
Senator Draheim offers the A17 amendment. The Secretary will report the A17 amendment.
Senator Draheim moves to amend the Lucero A15 amendment to Senate File Number 1750 as follows. Page 19, line 12, after not, insert. This is the A17 amendment.
Senator Draheim, to your A17 amendment.
Thank you, Mr. President. Members, the A17 is pretty simple, and it tries to address an alarming trend in HOAs, and that is the charges of fees to provide the paperwork the members of the HOA should have access to anyway. But currently, some management companies that run the HOA charge up to $1,000 to get the documentation needed or required to transfer ownership of their unit. And it becomes very expensive. So what the E17 does is just put a limit that they cannot charge more than $150 to furnish copies of any documents required to sell the unit. Thank you, Mr. President.
Senator Parr to the A17.
Thank you, Mr. President, and thank you, Senator Draham, for bringing this amendment forward. I stand in support of this amendment. This is something that needs to be put in place. To Senator Draham's point, there are HOAs right now that are charging anywhere from $100 to $1,000 for this document that homeowners must have in order to sell their home. So that means that if you don't pay this fee that's dictated by your HOA, you have no control over that, you cannot sell your house. And it doesn't matter that you're not making any money on your house. It doesn't matter if you're owing to sell your house. It doesn't matter if you're making tons of money. You're paying this fee for this document in order to sell your home. And honestly, this document is something that's already readily available to homeowners associations that they probably take no longer than 10, 15 minutes to put together, print, and send. Yet they're charging upwards of $1,000. So we have to put some limits on HOA's ability to charge for these documents to be reasonable amount. Members, I would encourage you to please vote yes for this so that homeowners are not stuck to a $1,000 bill in order to sell their home for a simple document. Thank you.
We're on the A17. All in favor say aye. All those opposed say no. The motion prevails. The A17 amendment is adopted. Any other discussions or amendments? Seeing none, the Secretary.
Hey, I'm standing, Mr. President.
Senator Westrom.
Mr. President, I would like to offer the A59 amendment.
Senator Westrom offers the A59 amendment. The Secretary will report the A59 amendment.
Senator Westrom moves to amend the Lucero A15 amendment to Senate File Number 1750 as follows. Page 54, after line 12, insert. This is the A59 amendment.
Senator Westrom, to your A59 amendment.
Mr. President, members, the A59 amendment would basically be some belts and suspenders on the question of what if an HOA has not updated their declarations or their documents, even though the statutes have changed. Many of these boards are volunteer. It's costly to update those documents, and so this language would be one simple sentence that just says the documents, if they're not updated, is permissible for the HOA. It's not a violation, although the current statute changes would still be in effect. It's just not a violation or necessary that they immediately go out and get their documents updated. Certainly more efficient if we'd let them do it as they're doing a rewrite for other reasons as well. And so this just clarifies that. Hopefully it's a friendly amendment with belts and suspenders just to make it a little easier for HOAs and not an immediate expense just because their documents aren't updated.
Senator Lucero to the A59 amendment.
Thank you, Mr. President, and I appreciate Senator Westrom coming in advance. So just to be clear, what we're discussing here, members, is on, let me pull up the actual page here. It's page 54 of the amendment. It reads, oh, you're adding at the end of it, it looks like. Okay, so without looking at the language in the amendment, my original A15 amendment, what this is doing, members, is we are creating provisions in here, such as conflicts of interest and other areas, fines and fees, whereas the bylaws or the governing documents of the association might be in conflict with the provisions that we pass, hopefully, in this amendment. What Senator Westrom is doing then is saying, when there's a conflict between the new, hopefully newly passed statute and the bylaw, that the statute prevails. That's what's in my bill / the A15. Senator Westrom's now A59 isn't changing that. Where there's a conflict, the statute will still prevail. What Senator Westrom's A59 is seeking to do is say, when that conflict exists, that the association doesn't have to immediately go out and change the verbiage of their bylaw. So the verbiage might still be in conflict, but the state statute is still going to prevail. That's what's at issue here. And Mr. President, if Senator Westrom would yield.
Senator Westrom, will you yield? He will yield. Senator Lucero.
Thank you, Mr. President, and thank you, Senator Westrom. I just want to make sure that I accurately described your position in your amendment, that when there's a conflict between statute and bylaw, statute prevails, and your amendment is just simply allowing for latitude to not immediately change the verbiage or update the verbiage within the bylaw.
Senator Westrom, directly to and specifically to the question.
Mr. President, Senator Lucero, that would be correct. That's the intention, and that's how I think the language is also reflected.
Senator Lucero.
Thank you, Mr. President. On that note, then I am in favor of that.
Senator Kroon.
Thank you, Mr. President. Well, Senator Westrom's amendment clarifies, I guess, that associations will not be forced to go out and redo all of their declarations and bylaws by law. I'm not sure that that law, or under the current bill, that requirement would have been existing anyway. The problem here is this raises a bigger point, which is that because of the retroactivity effect of this bill, associations, declarations, and bylaws are going to be in conflict with state statute. And this bill says that state statute controls. So just so this body knows, when you are looking at your declarations and your bylaws, they're probably not going to be what's actually governing. People will not be able to rely on what they say because of this retroactive effective date here, and that state statute will usurp what you've contracted for. When you buy a property, you are entering into a contract with your homeowners association based on the declarations and the bylaws and the governing documents. And once you've bought that property, what this bill is going to do essentially is alter that contract that you entered into when you purchased the home, because it will no longer be operative to the extent that it is conflicted with state statutes. So while Senator Westrom's amendment, I'll support it because it makes it clear that the law doesn't require the associations to go out and change their governing documents. The practical effect remains, which is that the associations will have a choice. They can either spend the time, energy, and money, and to change your governing documents can be quite expensive. They'll need to do that as a result of this bill change, or they'll just have to be at peace with the fact that their governing documents are no longer really operative to the extent that they conflict with state law, and that people, will have to consult with a real estate lawyer, or will have to be aware of this statute to know what the terms and conditions are of their agreement with their homeowners association. So while I'll stand in support of the amendment, I don't think this solves the underlying problem with the bill. Thank you, Mr. President.
Senator Latz.
Mr. President, members, I agree with everything that Senator Kroon had to say, but I'm going to amplify it and expand on it, because I've come to the conclusion that this amendment would not actually be helpful, because it's not exactly as Senator Westrom suggested, or Senator Lucero seems to be interpreting it, because they said that the amendment says that the HOAs would not need to immediately update their governing documents. But I don't see anything in here that says immediately. It simply says not required. Not required. And this would become effective January 1st, 2026. So this amendment would say they don't have to ever update their governing documents if the sole reason for doing so is to comply with the amendments in this act. And members, we've got a 54-page bill in front of us that makes changes all over the statutes that governing homeowners associations. So what are we going to do? Are we going to send this bill out to every property owner who's a member of a homeowner, who's in a homeowner association, to say, read the statute so now you'll know what, and go parse it with your existing governing documents and handwrite in the amendments so you know what the law actually says, so you know what your governing documents actually say, so that you know what rules and regulations you're supposed to comply with, because your HOA is not going to be required to tell you. You're going to have to guess, or you're going to run afoul of state statute. And you'll find out when someone complains and the HOA consults with their management company or consults with their attorneys at an expense, because the management companies and the attorneys aren't going to do this extra work for free. They're going to charge an additional fee to the HOAs to be responsive to this stuff. And they're going to give you an opinion. And then the HOA is going to go back and tell the homeowner, oops, sorry, even though it doesn't tell you in our governing documents, and even though we haven't told you anything at all about changes in state statute, you've got to comply. There is absolutely no notice requirement in this bill that I'm aware of. Chief author hasn't said there is one. Senator Westrom, who's the author of the amendment, hasn't said there is one. There's no requirement for disclosure by real estate agents on either side of the equation, the seller or the buyer. It says, by the way, you know, you should go read the underlying governing documents because you're buying into an HOA here. But no requirement that says they've got to tell you what the statutory updates are to it now, even though the governing documents that you're told to go read are no longer accurate. You are bound by the inaccurate governing documents because state statute has been changed, but no one's going to tell you what those state statutory changes are either. Just one more flaw in this underlying bill, because the HOAs under the bill and under this amendment will never be required to update their governing documents. Could be 20 years from now. If they haven't had a reason to update other than this, they'll be 20 years out of date, and no one's going to care.
Any other discussion? We are on the A59 amendment. Senator Klein.
Request a roll call, Mr. President.
Roll call requested, roll call granted. Any other discussion before we go to the author for the last word? Senator Pa.
Thank you, Mr. President. So I rise in opposition of this amendment. We are, although in our bill, we're not requiring that HOAs must change and update their governing documents. People should. And I think that there wasn't an agreement on what that should be. And so it is not included in our bill, but where we do want homeowners associations to update their governing documents with the laws that are passed, because to Senator Lass's point, they would be outdated. They would not be accurate governing documents. And so I cannot support this amendment. Thank you, Mr. President.
Senator Krohn.
Thank you, Mr. President. And it might begrudge me to say I think Senator Latz may have persuaded me on the merits of this underlying amendment. It's really a competing policy considerations between, do you want the documents, the governing documents, to be accurate, or because if you do, it's going to require the expense to change those governing documents. And I know it may seem like that shouldn't be an expensive proposition, but if you have a sizable homeowners association, it is a very heavy lift to change your governing documents, you certainly need to have a competent law firm that specializes in this area to make sure that you get it right. And who pays for that, Mr. President? Every single member in that homeowners association is going to have to pay for those legal fees and the implementation fees and the recording fees and all of the fees that go along with that. And I can tell you that the homeowners association that I live in just updated all of our governing documents, like literally a handful of months ago. And so now homeowners associations like this is a large homeowners association will be in a situation where they're going to have to, if they want to have accurate documents, they're going to have to go through that process again, which brings me back to my point that I made originally, that the more orderly way to do this would not to have it be applied retroactively, but only prospectively, so that it's for new homeowners associations coming in when they're creating their documents. Then they look to the statute, they draft their governing documents accordingly, or they have the opportunity to opt in when they're making that decision. They can factor in that they'll have to update their governing documents. So I don't know if this makes the bill better or worse. It depends on, do you want accurate governing documents, or do you want the costs? Because if you do, you need the costs associated with it. So I guess I will just leave it up to the body how to vote on it.
Senator Lucero.
Thank you, Mr. President. I share the sentiment of Senator Kroon in that Senator Latz was persuasive. And I think that this does, the language, the plain reading of it says they would not be required in infinitum. Well, I don't share Senator Kroon's sentiment that this is going to be massive amounts of money or labor expense. And the reason being, if there's a conflict, it will have to change. That's correct. A sentence, maybe a word. Many of these documents are going to be digital in nature, regardless of the size of the HOA. If there is something that's in silent, if the bylaw is silent, there's no updating that needs to be done. So, Mr. President, if there is a bylaw that permits or expressly states that a conflict of interest is okay, or allows for excessive fines or fees, allows for a lack of transparency, et cetera, that would be in conflict with statute, and then they would have to change their bylaws. But if it's silent, there won't be a conflict and there won't be an expense. So I expect there will be a nominal expense, obviously, for those bylaws that are in conflict, but there will be relatively few. And for that reason, then I would concur with my co-author, Senator Pa, in opposing this, as written.
Members, we are on the A59 amendment. I want to make sure there's no one else before we go to Senator Westrom so he can have the last word. Anyone else? Seeing none. Senator Westrom, you have the last word before we vote.
Mr. President, members, I want to redirect you back to the amendment language. One sentence, very simple, just to avoid costly updates to documents on January 2nd of 2026. It merely says that an association is not in violation solely for not having their documents updated. With these new statutory changes, they are still going to be in effect. This just says they are not in violation solely for not having their documents updated. It gives them the time in their normal course of business, which anybody in an HOA with some experience, they don't update them every year or two typically. And in smaller ones, which are more common in rural Minnesota, they might go 10 or more years before they update them or have a need to update them. And so this just gives that flexibility. To vote no on this means January 2nd, 2026, every last HOA better be finding an attorney, making sure that they are fully employed and that they've got their checkbook with tens of thousands of dollars collected from the HOA members to update the documents. Because I can tell you, the last HOA that had about a dozen members that I know of for doing a simple update was just about $10,000, between $5,000 and $10,000. So you talk a sizable HOA, I can assure you they are not going to get it done for $500. It will cost thousands and thousands of dollars to just do the record document update. And this just says, let them do it on their own time. It's not a violation if they haven't solely updated their records. That's all it says. It makes this bill better for the HOAs. The intent is still to make these reforms. But let's not get bogged down by adding thousands and tens of thousands of dollars January 2nd, 2026, to every last HOA in this state, because a no vote would do that. I urge your support, a green vote.
The Secretary will take the roll on the A59 Westrom Amendment. Senator voting, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Umu Verbatim votes no.
Senator Umu Verbatim votes no.
Senator Fate votes no.
Senator Fate votes no.
Senator Marty votes no.
Senator Marty votes no.
And Senator Murphy votes no.
And Senator Murphy votes no. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Lang votes aye.
And Senator Lang votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There being 20 ayes and 46 noes, the A59 Westrom Amendment is not adopted. Any other amendments? Senator Coleman.
Thank you, Mr. President. I'd like to offer the A58.
Senator Coleman offers the A58 amendment. The Secretary will report the A58 amendment.
Senator Coleman moves to amend the Lucero A15 amendment to Senate File Number 1750 as follows. Page 25, line 30, before the period, insert. This is the A58 amendment.
Senator Coleman, to your A58 amendment.
Thank you, Mr. President. Members, I'm hoping this will be a friendly amendment. Essentially, where this stemmed from was I heard from HOAs in my district that agree that there are some bad actors when it comes to conflicts of interest, but explained to me that the origins of theirs were, for example, they would try to get some sort of contractor out, or a contractor would do bad work, or a maintenance person would work on the wrong unit and they couldn't get a hold of them. And so they created these maintenance companies in order to have accountability, because therefore they have to answer to their board members. They have to answer to the members living in the homes. And so what this does is it inserts in the portion about bidding and all of that with board members on page 25, line 30, unless the material financial interest is disclosed to the board members and recorded in the meeting minutes. That way there's transparency all around about what's going on and allows these companies to continue operating with efficiency if that's what their board would like to do. So happy to answer any questions.
Senator Lucero to the A58 Coleman Amendment.
Thank you, Mr. President. Thank you, Senator Coleman. So I'll just read what this will do then, if adopted. So the sentence will read, a board member must not participate in deliberations or vote on the approval of a contract where the board member or family member of the board member has a material financial interest in which it is likely to result in financial gain, unless the material financial interest is disclosed to the board members and recorded in the meeting minutes. I am fine with that. I would accept this as a friendly amendment.
Any other discussion? Senator Latz to the A58 Amendment.
Mr. President, members, I generally would support disclosure requirements, and as far as that goes, that's nice. I don't think it necessarily solves the problem because there are plenty of HOA boards where the president of the board or some member of the board has a significant amount of influence over the voting members of the board, or is the only one who's really paying close attention to things. Simply disclosing that they have a financial interest or that they've got a son or a daughter who works for such and such a company that's going to come in and paint the ceilings may not be enough. The other members may just say, okay, that's fine. Okay, that's fine. Disclosure is nice, but I don't think it's necessarily going to solve the problems.
Any other discussion on the A58? Last words from Senator.
Just a roll call, Mr. President.
Senator Parr.
Thank you, Mr. President. Will Senator Coleman yield for a question?
Senator Coleman will yield. She will yield. Senator Parr.
Senator Coleman, thank you for bringing this amendment forward. I just want a clarification on your amendment here. Are you saying that in your amendment, are you saying that board members, if disclosing their financial interests, now they can deliberate on the issue or the bid or the contract and vote on that now? I just want to clarify that.
Senator Coleman to the question.
Thank you, Mr. President. Thank you, Senator Pa. Yes, this is saying that they are able to participate in these conversations if they are being upfront and honest and transparent with any interest they may have in it.
Senator Pa.
Thank you, Mr. President. Thank you, Senator Coleman, for clarifying that. I just want to make sure that I understood it correctly. With that clarification, I'm going to recommend a no vote. The reason why I say that is because we specifically put in here that board members cannot participate in deliberation or vote, so that there isn't a conflict of interest, especially if there's a financial interest. And so I would say no to this, because now those board members could vote. And the deliberation, when we've had conversations with board members and HOA homeowners, the deliberation wasn't so much the issue, it was the vote. But because this says deliberation and vote, I would say no to this.
Senator Coleman, I will give you the last word, because usually in our process, we always let the author have the last word, but Senator Pa did stand up at the last minute, and I wanted to make sure we acknowledged her, and I wanted to be consistent with our practice. Senator Coleman.
Thank you, Mr. President. Thanks for the feedback, members. And, I'm a co-author on the original bill, so fully agree with the intent. However, I think that some portions, particularly this one, is going to punish good actors and that are just trying to be efficient and provide good services. So I believe this amendment addresses that, and I would request a roll call.
A roll call vote was requested and a roll call granted. Members, the Secretary will take the roll on the A58 Coleman Amendment. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Fate votes no.
Senator Fate votes no.
Senator Marty votes no.
Senator Marty votes no.
And Senator Murphy votes no.
And Senator Murphy votes no. Senator Jasinski, those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Lang votes aye.
And Senator Lang votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There being 32 ayes and 34 nays, the A58 Coleman Amendment is not adopted. Any other amendments? Seeing none, Senator Kroon.
Thank you, Mr. President. I'll offer the A56.
Senator Kroon offers the A56 amendment. The Secretary will report the A56 amendment.
Senator Kroon moves to amend the Lucero A15 amendment to Senate File Number 1750 as follows. Page 13, lines 12 to 19, delete the new language. This is the A56 amendment.
Senator Kroon to your A56 amendment.
Thank you, Mr. President. The A56 strikes the added language in lines 13.12 to 13.19, which is the affirmative consent of first mortgagees that I've previously discussed as one of the concerns I have on this bill. And I understand that I've been told that that this language has been given to the Bankers Association and other people regarding the Bankers Association, but I've not had a chance to speak with any of them, and I have very serious concerns about what this clause is going to do to the marketability of properties subject to HOAs, because if people run into difficulty getting financing and mortgages for HOA property, then that's obviously not something that is desirable. And so what the existing language does, Mr. President, in this bill is it reduces, to dissolve a CIC, the threshold of the vote from 80% to 60% in certain situations. And normally, what it also does is it allows the Homeowners Association to send notice to mortgage holders, first mortgage holders, and gives them 60 days to consider whether they consent, and if they don't respond, then it is implied that they are voting yes and are affirmatively agreeing to that. I think there's problems with that, as I said, but there's one of the things I'm wondering about, and I maybe if Senator Lucero might yield for a question.
Senator Lucero, will you yield? He will yield. Senator Kroon.
Thank you, Mr. President. And Senator Lucero, do you know if there's been any discussions whether or not this requirement, this implied consent requirement on mortgage holders, whether that would be allowed under Fannie Mae or any other lender guidelines?
Senator Lucero, to the question.
Thank you, Mr. President. I apologize. I'm receiving multiple communications here. I did not hear the tail end of the question. I will say that this was a suggestion. I don't want to violate protocol and mention a lobbyist name, but it was a suggestion that we took. It wasn't organic from one of us. So I'm actually fine if we want to remove this. To be honest, that's the communications I'm receiving here. So I know I did not answer Senator Kroon's question. Senator Kroon, if you wanted to ask it again, I'll listen more intently this time.
Senator Kroon.
Thank you, Mr. President. Senator Lucero, maybe I'll ask a different question this time. Mr. President, if Senator Lucero would yield.
Will you yield? He will yield. Senator Kroon.
Maybe the first question I should have, Senator Lucero, is would you accept this as a friendly amendment?
Senator Lucero, will you accept this as a friendly amendment, was this question?
Yes.
Senator Kroon.
Thank you, Mr. President. Then my second question is irrelevant, and that's all I have. Encourage members to vote green, or vote yes.
Senator Powell, to the question, to the A56 Kroon amendment.
Thank you, Mr. President, and thank you, Senator Kroon, for bringing this amendment forward. I don't object to this. I would also consider this a friendly amendment, but I do just want to clarify that I spoke on this before, but this 60 days, no response after the forced mortgagee receives the association's notice of termination, if the 60 days after, this was vetted and seen by the Minnesota Bankers Association, by the Credit Unions Network, and they had no concerns about this. And we haven't heard concerns from, honestly, any of our stakeholders regarding this provision. But I'm also in favor of this friendly amendment and the deletion of this provision. Thank you.
Senator Latz.
Members, I just want to point out that this is the point at which, in a committee, we would have called forth the representatives from the Bankers Association and the Credit Unions Association, and maybe some consumer rights organizations, and gotten some direct expert testimony on what the effect of this would be. Because in effect, what you've got is a default provision in here for failure to respond to a notice that might have gone to whatever address was provided in the recorded instrument, even if someone had forgotten or didn't update the address in their recorded interest that evidences the security interest. So someone doesn't update their recorded instrument address. That's where a notice goes. They no longer live there. They haven't for a few years. There's no forwarding. No response is received, and a mortgagee's interests in the property gets terminated because of that. That's the language that's in the bill, or in the delete everything amendment. Senator Kroon, I think, is doing a good thing here to try to get rid of that language because of that flaw. But my main point here was, this is where in a committee we call forth the stakeholders to talk to us about it. And we have a discussion about it and figure out if there's any language that we could put in here that might save the goal of it without creating a default rescission of a mortgage interest. That's the problem with doing this on the floor, members.
All in favor of the A56 amendment say aye. Aye. All those opposed say no. The motion prevails. The A56 is adopted. Any other discussions? Senator Kroon.
Thank you, Mr. President. I would like to offer the A60.
Senator Kroon offers the A60 amendment, and the Secretary will report the A60 amendment.
Senator Kroon moves to amend the Lucero A15 amendment to Senate File Number 1750 as follows. Page 26, line 16, delete solicit a minimum of 3 written competitive bids and insert. This is the A60 amendment.
Senator Kroon, to your A60 amendment.
Thank you, Mr. President. I was going to offer this amendment after Senator Coleman's, but I noticed a slight problem with it, so I had to get it redrafted, and here we are. So this goes back to the conflict of interest provisions just after the provision that Senator Coleman had an amendment on. So we're on page 26 with my A60 amendment on that amends the A15. And I've stated, Mr. President, my concern over requiring 3 written competitive bids prior to entering into any contract for property maintenance, construction, repair, or reconstruction services with an estimated cost exceeding $50,000. I would first like to thank the bill authors for, I believe, increasing that threshold number. I think that's important, but I still have very serious concerns about this provision, and I think it could be better addressed through simple disclosure requirements, and that's what my amendment seeks to do. It says where it keeps the 26.4 to 26.6 language in there, but then rather than requiring written bids, it instead just requires disclosure of the affiliated companies and board member families and all that kind of things, rather than requiring it to go to a bid, Mr. President. And one of the things I have concerns about here with this competitive bid process is how this is going to work. And I raised this, I don't know if the language was different in judiciary, but I think this general provision was in the bill at the time of judiciary, and this was one of the issues I raised in Judiciary Committee and asked the bill authors that before this got to the Senate floor, that this prohibition on contract, or this requirement of the 3 written bids, should be replaced with a more general disclosure requirements. And so I'm following up on that discussion from Judiciary Committee. And one of the concerns I have is how this is going to work with insurance claims. And so if Senator Lucero would yield for a question, Mr. President.
Senator Lucero, will you yield? He will yield. Senator Kroon.
Thank you, Mr. President. Thank you, Senator Lucero. Can you walk me through how this requirement to solicit a minimum 3 written competitive bids would work in a situation where there is an insurance claim?
Senator Lucero, directly to the question.
Thank you, Mr. President. I'm going to give a little bit of background on this provision. By the way, I oppose this amendment. So what we wanted to do here, we heard testimony that some property management companies were steering, when it came to repairs, steering the contracts to companies without a competitive bid, and companies of which they had a financial relationship with. This provision is in here because it is a best practice to require bids. We do not want to delete the requirement of having competitive bids. And so we want to stop the steering process. And then the other thing I want to put forward, Mr. President and members, many of us in here are former city council members of some capacity. And what we tried to pattern this after, and for those who are former city council members like myself, we are familiar that we as a council, when we have to go out for bid for some product or service, we have to get competitive bids. And we attempted to pattern that established process here. So this is an example of what I was saying earlier, Mr. President, that this is not something wrong with the language. This is just a disagreement on what the language currently is. And wherever you draw that line, there will be people that disagree. I firmly believe there should be competitive bidding, and I would not agree that just because somebody discloses they have a financial interest, that that would be good enough. So I oppose the amendment.
Senator Kroon.
Thank you, Mr. President. Thank you, Senator Lucero. It is a certain policy agreement, but I'm still concerned. I didn't hear in your response the answer to my question, which is how this relates to insurance claims and what would happen in a situation where the process set forth in this bill is in conflict with the process that's required under an insurance policy. What is a homeowners association supposed to do in that situation? Do they run afoul of the process set forth in their insurance contract, or do they run afoul of state statute? That's my concern here, because it's a rather prescriptive process with a lot of requirements, and I don't think that all of these requirements have been vetted in terms of how that works with insurance claims. I would also like to say, Mr. President, that it sounds good, and I agree that we don't want boards steering contracts towards affiliated companies and all that sort of things, but some of the times we're talking about things that are good for the homeowners association, to be able to contract with affiliated companies, to have that relationship built in, to know that the work is going to get done, to be able to rely on a company that they work with. And as long as that's disclosed, and as long as everybody knows about that affiliation, it doesn't make it inherently wrong. And then to require them to go out and do a formal bid with 3 bids is a burdensome process. And keep in mind, Mr. President, a lot of these homeowners associations are small. And whether they're big or they're small, we're talking about volunteers that are serving on the board. One of the biggest things that I've heard when talking about homeowners association boards is that they can't find people to be on the boards. Nobody wants to serve in this role. And with a bill like this, I can't blame them. Why would you want to do that to yourself? They're unpaid, they get a lot of flack, and this is another provision that is going to make it more difficult for them to do their job. And I think this is, even if it isn't a perfect solution for people that are concerned about bad actors, it is a step in the right direction to have a disclosure requirement. And without having thought through all of the unintended consequences, we as a deliberative body should maybe take that first step and don't let the perfect get in the way of good. And so I think it's a step too far right now to go into this long process of requiring minimum 3 bids rather than just having a simple disclosure requirement, and then see how that addresses the problem while avoiding those unintended consequences. So, Mr. President, I would request a roll call.
Roll call requested, roll call granted. Senator Pah.
Thank you, Mr. President. And thank you, Senator Kroon, for bringing this amendment forward. I just wanted to encourage members to vote no on this. And we have spent an enormous number of hours on just this one provision in discussion, and with all of our stakeholders extensively, because we wanted to make sure that it wasn't something that was going to be a burden for board members in HOAs, but at the same time, it puts in place the protections that need to be in here. In fact, some of our Homeowners Board Association members have said this is what they want because they've had to fight with their own members about getting multiple bids. So just to clarify that we're saying you must solicitate a minimum of 3 written competitive bids for contracts over $50,000. That means anything under does not apply. They can, that would be great practice, but it is not required. Anything exceeding $50,000 would be. And these are the exceptions to that multiple bid. Any projects that are doing emergency repairs to protect the health or safety of unit owners, anything that's covered by warranty already does not need multiple bids. And multiple bids, if they can demonstrate that they made a reasonable effort in getting multiple bids, but were not able to get the 3 multiple bids, that would meet the requirement. So, Senator Kroon, I can't support your amendment because this has been, again, thought thought through very thoroughly in trying to find an agreeable something that would work in real world HOAs between homeowners associations, and contractors and stakeholders when it comes to this competitive bid process. To your question about the insurance, most insurance, if there is an insurance claim, most insurance require multiple bids anyways. But there's nothing in this section that would prevent people from an HOA from being able to work with their insurance on getting payment for projects because, like I said, emergency repairs, anything that's covered by warranty, or that they can demonstrate reasonable efforts in getting these multiple bids, but we're not able to attain it. So that meets the criteria. Members, I hope that you will support me in voting no for this amendment.
Senator Latz.
Will Senator Powell yield for a question?
Senator Powell, will you yield? She will yield. Senator Latz.
Mr. President, Senator Powell, I'm looking at the bill on page 26 where this amendment would go. It looks like on line 10, it sets criteria by which the board must make their decision about which vendor to select. So not only does the proposed bill require a solicitation of 3 written bids, but then it also requires in statute the manner by which the board must make a decision between any bids. I don't see anything in there that talks about just a level of confidence that the board may have that a particular bidder is going to do the job the best. And I don't see anything in there that talks about a desire to build a long-term positive business relationship with a particular contractor because they may have future contracts that'll be for $49,000 or $10,000 less than the requirement for multiple bids that they want to be able to turn back to that contractor, and they're going to get maybe a better deal next time because they've got a long-standing relationship, because it's an ongoing customer relationship. Am I missing something in here, or is that a criteria? Could a board simply say, you know, we got 3 bids here, one of them is $10,000 higher than the other, but you know what? We really have a lot of confidence in this particular company. We want to develop a long-term customer relationship with this company, so we think it's worth the extra $10,000. We're going to do that. Would that be allowed under the bill that's proposed?
Senator Powell, specifically to Senator Lass's question.
Thank you, Mr. President. Thank you, Senator Lass, for that question. So on 26.10, it says on here, the board must review all bids and select a vendor based on reasonable business criteria, including but not limited to the cost of the project, the contractor's qualifications, available warranties, the extent to which the bidder has met the bid solicitation requirements, and the length of time estimated to complete the project. That means that they've got a lot of things that they can consider, in which any of these things can outweigh the other, depending on what their priorities are, depending on the project that they have ahead of them, and what they want to accomplish with that project. And so it gives board members some guide into what they should be looking at, but it does not limit them as to or tell them how they should decide on these contracts.
Senator Latz.
Mr. President, will Senator Powell yield for another question?
Senator Powell, will you yield? She will yield. Senator Latz.
Senator Powell, how is reasonable business criteria defined? I mean, under current Minnesota law, board members of a corporation have protections under the business judgment rule. Is this language intended to contest the decision-making authority of the board if owners disagree with decisions?
Senator Powell to the question.
Thank you, Mr. President. Thank you, Senator Latz. So reasonable business criteria is following that. We named a few of them, which is like contractor qualifications, available warranties, the extent of the bid, that's listed on from 26.10 all the way to 26.13. It is not meant to limit HOAs in their ability to decide on which contractors they will go with depending on what their priorities are.
Senator Latz.
Mr. President, now I'm really confused because the next 10 lines seem to do precisely what Senator Pah just said it's not intended to do, which is to limit the discretion of the board in deciding which vendor to select. So I think this provision still needs some work. And so I think the amendment would be a good idea at this point. But even with regard to the amendment, I think there's a typo in the amendment because on line 26.6, the word all is capitalized, and it seems to me the amendment should have that replaced with a lowercase. Although I'm reaching back here a number of years, I think we once had a discussion on the floor that maybe that's something the revisor's office does without having to specify it in the amendment. This is the point at which I would turn to counsel in a committee hearing and say, do we need to fix the amendment or don't we? But we're not in the committee, we're on the floor here. So at this point, members, I think disclosure should be plenty, and I'd support the amendment.
Senator Lucero.
Thank you, Mr. President. I just want to reiterate that this language is good. The amendment, the Kroon amendment, is bad. We want to have competitive bids, and this is not a new concept. And I will reiterate the language. Based on the board shall review the bids and select a vendor based on reasonable business decision. It is a reasonable business decision to use an insurance company first or as part of that process. And in terms of Mr. President, Senator Latz's concerns on a business relationship, the verbiage goes on 26.11 that says a contractor's qualifications. It is a qualification to have a standing relationship and understand that's part of the qualification. And so that is in here. These concerns that are being raised are not anything that needs to be added in this amendment. I encourage members to vote red on the amendment, and I will end by saying as a reminder that this language here was suggestions from CAI and large management companies. The verbiage in that we're seeking to amend is already suggested language. Let's leave it as is and vote red.
Senator Pratt.
Thank you, Mr. President. Would Senator Pah yield for a question?
Senator Pah, will you yield? She will yield. Senator Pratt.
Thank you, Mr. President. Senator Pah, you said that insurance companies require multiple bids. That may or may not be the case. If an insurance company tells a homeowners association to get a bid so that they can determine whether it's reasonable or not or pay it, would this provision still require a minimum of 3 bids?
Senator Pah.
So thank you, Mr. President. Thank you, Senator Pratt, for your question. I just want to clarify that I said most insurance companies often already require, I didn't say all. So just to clarify on that. 2 is that if they do not, insurance companies do not require multiple bids, this would still apply. But again, only if the cost exceeds $50,000 and if they've made a reasonable effort in obtaining multiple bids but cannot obtain multiple bids. Or if the work is already covered by warranty, or if it's an emergency repair to protect the health and safety of unit owners. So there's many things in here that would cover for some emergency insurance claims.
Senator Pratt.
Thank you, Mr. President. Well, Mr. President, I'm not sure that most require multiple bids. In fact, they may say just go get a bid and get the work done as long as it's reasonable. My concern is that as we start talking about reasonable business criteria,
one of the factors not listed in this list is speed. If your roof is damaged and you get a qualified bid and the insurance company is willing to pick it up and they can start very, very quickly, we should get that done versus having to wait for 3 bids. I think this is a well-intentioned provision, but I support Senator Kroon's amendment. I don't know that this language has been fully vetted. If we're talking about cosmetic, if we're talking about non-urgent projects, then yes, I think this probably is a good business practice. But for those where we're talking about a sense of urgency, I think speed is of the essence, and we need to be able to get that done. We shouldn't be stepping on the relationship between the insured and the insurer, which Senator Pah just said we'll be doing here. Thank you.
Senator Gruenhagen.
Well, thank you, Mr. President. Yeah, since I own an independent insurance agency and we got a lot of property insurance, I would just reiterate some of the statements that President Pratt just said. I just claims this year, if it's a large claim and the bid is unreasonable, the adjuster will require a second bid. So we're kind of inserting ourselves in that insurance adjuster client relationship, which I don't, if you find a reasonable bid as far as the insurance company is concerned, why wait till 3 different bids are concerned when you have damage that can be ongoing? So I do rise in support of Senator Kroon's amendment, and I think disclosure covers this, and give the insurance company and adjuster credit. They deal with this on a regular basis. They've been educated in this. They've seen numerous claims, and if they want an additional bid, they think it's unreasonable, they'll request that before they make a settlement. So please vote green. Thank you, Mr. President.
Senator Lucero.
Thank you, Mr. President. I just want to reiterate why the concerns that Senator Pratt raised are not founded. I would draw attention to lines 26.14 through 19 or 20, and it says, for example, on 2616, emergency repairs are not, this is an exception, if emergency repairs are required to protect the health or safety. So if there is urgency, which is one of the scenarios that Senator Pratt brought up, that's already exempt. We've accounted for this. This is vetted language. It is suggested language. It's mature language. Let's reject the amendment and move on. Thank you.
Senator Kroon, let's see, Senator Dames.
Well, thank you, Mr. President, and I'd rise in support of Senator Kroon's amendment. When you get the insurance involved, if you can make an arrangement with the insurance company, if you've got a bid, you ought to be doing that. Now, what the emergency situation is, I don't know how clear you're going to be on what the emergency situation is. I think actually this amendment maybe should include some language that exempts the insurance claims on this particular thing to get 3 bids, because some insurance companies might require more than 1 bid, but usually that is not the case. Usually they get 1 bid, they work with that contractor and come up with what needs to be done and what the cost will be, and they can go ahead and start doing the work. If you're going to get 3 bids, you never know just where you're going to end up at. So I would support Senator Kroon's amendment.
Any other discussion before we go to the author of the amendment? Who will be the last voice that we will hear before we vote? Seeing none, Senator Kroon, before we vote.
Thank you, Mr. President, and thank you, members, for the discussion. I think the insurance provision was well said by other members, and I think that's one example of why we should vote for this amendment, just to make sure that we're not getting in between the HOA and the insurance adjuster, or putting them in a situation where they have to choose between following their insurance provisions or state statute. I would also note that, yes, there's an exception for emergency repairs if they're required to protect the health or safety of the unit owners, but I can think of a lot of other urgent matters that maybe don't necessarily rise to the level of an emergency repair to protect the health or safety of the unit owners, but I can guarantee you that the homeowners are going to want it taken care of urgently. And so you have a situation where you have an existing relationship with a company that has done work for you. You have something that your homeowners are going to want done immediately. They're going to expect that this gets done right away, and then you can't because it costs more than $50,000, and you're going to have to go out to a bid, get 3 bids, where how quickly that contractor can do it isn't even a criteria. I can't imagine how upset the homeowners are going to be in a situation like that. And the people on their board are going to bear the brunt of it, but the responsibility lies with this chamber, not with them, if we don't pass this amendment. And I think we need to take a more deliberate approach here. And also, I would say, Mr. President, that down here in lines 26, 22 through 27, there's additional burdens placed on the board. They have to maintain records of these bid selection processes and contracts awarded and have them available for inspection for a period of 6 years. I don't know exactly where that inspection will take place or how that process is going to work, but for 6 years, somebody can go in and demand, and what's the penalty if that isn't complied with? And then beyond that, there must be a report prepared by the board of directors listing all the contracts for goods and services of the previous budget year, including et cetera, et cetera. And I would just say these are well-intentioned, Mr. President, but they're going to add a lot of burdens onto the boards, which I've previously said, these are volunteer positions. Some of them are small. And they're going to have to deal with this. And even if they're big, it's going to add costs because they're going to have to farm these things out to the professionals that will charge a cost. And who's going to pay for that? It's going to be everybody who lives in a homeowners association. So, Mr. President, I think this is a good amendment that has, we've identified some problems here. I would support members to vote green on this amendment, and I thank you for your time. Thank you.
The Secretary will take the roll on the A60 Croon Amendment. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Marty votes no.
Senator Marty votes no.
And Senator Murphy votes no.
And Senator Murphy votes no. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Miller votes no.
Senator Miller votes no.
Senator Housley votes aye.
Senator Housley votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye. Members, please vote. All senators having voted who desires to vote, the Secretary will close the roll. There have been 26 ayes and 39 noes. The A6 Croon Amendment is not adopted. Any additional amendments? Seeing none, the Secretary will give the bill its third reading.
Senate File Number 1750, a bill for an act relating to common interest communities, modifying powers and duties of common interest communities.
Third reading. Any other discussion before the last voice we hear will be the author, which is Senator Lucero. And before Senator Lucero, if there are any comments from Senator Pye. Anyone else before we go to those two individuals? Seeing none, the last two voices, Senator Pye followed by Senator Lucero. Senator Pye.
Thank you, Mr. President, and thank you, members, for this robust discussion and the amendments that were brought up. I appreciate everyone's consideration of this bill. I want to thank all the staff. I'm going to let Lucero kind of go down the list, but I just want to say I want to thank all the staff that helped us put this bill together. Thank all the stakeholders who engaged with us during this entire process and helped create this bill to where it is today, a much better bill than what we started out with in January. I want to thank especially the 20-member work group that this legislature put together so that they can work on the HOA and CIC issues that are facing Minnesota. Members, I encourage everyone to please vote green.
Members, before we go to Senator Lucero, I was told that someone had stepped out and did not hear the announcement that I wanted to go to the last two. And members, if you could be so kind as to stay as close to the chambers, that would be great. Senator Latz.
Mr. President, members, I actually had stepped out and I did hear the announcement. So you can imagine where I went when I stepped out. It's a long debate, members. We've spent 2.5 hours on the Senate floor here reviewing, amending, trying to fix a bill that is flawed in many of its elements. And I regret to say I'm going to have to vote no. Members, an amendment was adopted, the A19 amendment. It has a direct impact on local governments. In fact, the amendment's captioned local government regulations. This provision was in the bill when it came to the Judiciary Committee, and it was amended out of the Judiciary Committee so the bill would not have to go to the State and Local Government Committee and instead would meet deadline. Now, that's not unheard of. But then to come back on the Senate floor, having bypassed the committee process, avoided State and Local Government Committee, and then come back here and offer the A19 amendment and say, oh, let's just do it on the Senate floor. That's a gross distortion of the process that we have set here in the Senate for policymaking. And it will hogtie local governments because it does more than simply prohibit a local government from requiring HOAs, even though that was the final pitch to the members on the floor here. As I pointed out in the discussion, it also prohibits local governments from requiring any terms to HOA declarations, bylaws, articles of incorporation, or other governing documents. So even if a developer wants an HOA, what they end up doing by that is exempting themselves from any HOA-specific type regulations a local government might wish to impose. So it might, in fact, have the perverse effect here of encouraging developers to create HOAs because they know once they do that, they're only subject to state statute and won't be subject to any specific local government initiatives. Members, the failure of the A59 amendment dealing with updating documents is probably going to cost thousands and thousands of dollars, as was already described. Someone mentioned $10,000 in attorney's fees for HOAs, which will get passed on to their members their owners to bring their governing documents into compliance with a new complex statute. And not only that, but the HOA management companies are going to charge extra to their HOAs to facilitate the work. We adopted an amendment here, the A17, that prohibited charging an amount greater than $150 for furnishing copies. You know, I didn't endeavor to engage in a conversation on that, but there was no description of where that dollar amount came from. For all we know, is simply an arbitrary selection. I don't know, it's more than 100, which is the lowest number we've heard, but it's far away from 1,000, which is what we've heard some HOAs are charging, so let's pick 150. Not in any way linked to the actual cost of providing documents. I don't know what that actual cost is. In committee, I would have asked the question. Members, we did deal with the issue of disclosing conflicts of interest and ended up creating a binary distinction between two options. The original bill says, absolutely, if there's a conflict of interest, you can't vote on it. The amendment says, unless it's disclosed. I'm going to respectfully suggest that that whole section could have benefited from a lot more work. That there's probably a more nuanced way to address conflicts of interest than saying all black or all white. If there's disclosure and certain other criteria are met, then it's okay. Something like that. I don't know what those criteria are. I would have asked the stakeholders to sit down and come up with some suggestions that don't force such a black and white choice, that maybe leave room for board members to vote if certain criteria are met, even if they are able to disclose and deal with other aspects of it as well. And with regard to the competitive bids, I mean, we had a long conversation on this. The conversation itself proved how complex that issue is and that there may be additional work that should be done on that provision. From insurance claims and others. Why we had that discussion here on the Senate floor, it's a little bit beyond me, members. There's a reason that we have process. And so much of the reason that we've been told here today that we should bypass the process is because this is absolutely urgent and because the authors have spent hours and hours and hours working on it. And you know what? I respect the need to do something here, and I respect the amount of work that it takes to work on a topic that's this big. And I haven't even begun, and I'm not going to spend the time now working through the bill section by section to tell you that the term property management company isn't defined, that the term material financial interest is not defined, that elsewhere the term management company is used instead of property management company. Are they supposed to refer to the same thing or aren't they? And how are they defined? These are the kind of things, members, that leave ambiguity in statutes, that lead to confusion and lawsuits, and that could and should be addressed in the committee process. This bill is rife with difficulties like that. It is simply not ready. And as much as I would love to see a lot of these problems addressed, as much as I would love to see more affordable homes built, in Minnesota. And frankly, as much as I would have liked to have made a motion to re-refer this bill to state and local governments so the proper committee could vet its issues, I'm simply going to encourage members to vote no on the bill because it's not ready to become law.
Senator Latz, thank you. Senator Lucero, we are now hear your last voice before we vote for final passage as amended of Senate File number 1750. Senator Lucero.
Thank you, Mr. President. Thank you, members. I appreciate the comments from Senator Latz and Senator Kroon and all the members that have spoken. But I deeply, deeply appreciate the energy, the time, the partnership with Senator Pa on this issue and the others that have reached out and have been rolling up their sleeves and working with us, both members, stakeholders, constituents, all across the board. While we have been discussing for 2.5 hours or so on the floor, we have been working at this since September. We're roughly 9 months. We have gone over and over, received information, feedback, incorporated it, and this is a good bill. It is a good bill. It focuses on ending the conflicts of interest, addresses the excessive fines and fees. It ensures an end to the lack of transparency. It reins in the exceeding and sweeping powers of HOAs, the exploitation that our constituents are experiencing. This is a pro-consumer protection bill. It is end-to-end common sense reforms. It balances the scales between residents, boards, and property management companies. It ensures the transparency and accountability. It has a framework for dispute resolution, and on and on. I also want to thank for the leadership of Representative Bonner in the other body, Representative Meckland, and some of the lobbyists who've been working with us day after day. This is a good bill, members. Vote green. Thank you.
The Secretary will take the roll on final passage as amended of Senate File 1750. Senator voting for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
And Senator May Quaid votes aye.
And Senator May Quaid votes aye. Members, please vote. Senator Jasinski for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Housley votes no.
Senator Housley votes no. All senators having voted who desires to vote, the Secretary will close the roll. There have been 44 ayes and 22 noes. The bill is passed and its title agreed to. Members, we will now go to Senate File 2300, Senator Seeberger.
Thank you, Mr. President. Senate File 2300 makes modest, common sense improvements to our Earn Sick and Safe Time program here in the state of Minnesota. And in response to concerns raised by businesses across the state, after enactment of this law. While there's no question in my mind that this law makes needed improvements in our worker protections in this state, there are some areas of improvement. Following the enactment of Earned Sick and Safe Time, I have heard many stories from employers about the misuse of this program by their workers and the burden it has put on employers. For example, I have heard examples of workers taking Earned Sick and Safe Time to prolong a vacation or a weekend when they are not actually using it for an illness or for safety reasons. I have heard of an employee calling off a shift on short notice and using Earned Sick and Safe Time because their car wouldn't start. Not only does this impact the employer's ability to maintain adequate staffing, it puts a burden on the other workers who now need to pick up the slack. We see this in school districts when there is no substitute and teachers must use their prep time to provide coverage. I've seen this in my own job as a paramedic. Where I work, we have between 2 and 3 trucks on, meaning we have a crew of either 4 or 6. If one person calls off, misusing their Earned Sick and Safe Time, that leaves us down a truck, and that means the rest of us have to pick up the slack. While the protections of workers is a priority for me, we cannot ignore the needs of our business community. Senate File 2300 addresses these concerns and offers improvements to an important program within our state. The improvements made by my bill include changes to the notice and documentation provisions, to the more generous leave provisions, and clarifies concerns with regard to front-loading of Earned Sick and Safe Time. With regard to notice provisions, 2300 would change language so that if the need is unforeseeable for an employee to use Earned Sick and Safe Time, it changes the notice time from as soon as practicable to as reasonably required by the employer. With regard to the documentation provisions, Senate File 2300 changes the documentation obligation from when an employee uses Earned Sick and Safe Time for no more than 3 days, it changes it to 2 days. Then an employer may require reasonable documentation to support the Earned Sick and Safe Time used. So we're changing a 3-day to a 2-day. Changes it to 2 days, then an employer may require 2-day. It clarifies that there's nothing in the law that prohibits an employee from voluntarily seeking or trading shifts with a replacement worker to cover hours the employee uses it as Earned Sick and Safe Time. And finally, with respect to more generous sick and safe time policies an employer may have, the protected time, the amount of protected time goes back to the amount of protected time employees had before Earned Sick and Safe Time was enacted in 2023, which is 160 hours. Mr. President, 160 hours for someone who works 8 hours a week, or 8 hours a day, 40 hours a week, is 4 weeks of sick time. It also clarifies that an employer cannot require an employee to use their protected hours before accessing the rest of their duly earned PTO, thus giving employees the freedom and flexibility to use their PTO as appropriate. Finally, there was concern from the employer community with regard to folks who are hired mid-year and being able to front load Earned Sick and Safe Time without a proration for the amount of time they actually worked in the year. Senate File 2300 clarifies that an employer is permitted to advance Earned Sick or Safe Time based on the number of hours the employee is anticipated to work. So it clarifies that equity is already built, equity with regard to amount of Earned Sick and Safe Time an employee qualifies for is already built into the bill, but we've clarified that so that it is clear for both employees and employers. Unfortunately, the provision of 2300, Senate File 2300, that would have given much needed relief to micro businesses was amended out when the bill was heard in the Rules Committee. It's unfortunate that the burdens put on small businesses have been discounted and perhaps ignored. Our duty after we pass a bill is to come back and make adjustments when something isn't working as well as it should. We can't and we shouldn't hide our head in the sand and pretend that everything is perfect when in reality there are meaningful opportunities for improvement. I want to thank the Earn Sick and Safe bill author, Senator Pappas, for her willingness to listen to the concerns of the business community and to roll up her sleeves with me to help make the bill better. Senate File 2300 in its current form reflects an agreement made with Senator Pappas to improve the Earn Sick and Safe program, and I am grateful for her hard work. I want to thank the Majority Leader for allowing this bill to be brought to the floor, knowing it represents a difficult compromise for many of my Senate colleagues. I want to thank the Labor Committee Chair, Senator McEwen, for the open discussion and clear communication regarding this bill. Even though I know that you are opposed to this bill, you have been gracious and honest about the points we do not agree on. And finally, I want to thank Senator Rasmussen for all the work he's done to find common ground on the areas that we can improve with this bill. This bill represents a true bipartisan effort. Members, I urge you to recognize the very real needs of our business community and vote yes on these modest, common sense improvements to our Earn Sick and Safe laws. Thank you, Mr. President.
Senator Dornick.
Thank you, Mr. President. First, I want to thank Senator Seeberger for all her hard work on this, and I stand in support of the bill. I do want to offer the A5 amendment.
Senator Dornick offers the A5 amendment. The Secretary will report the A5 amendment.
Senator Dornick moves to amend Senate File Number 2300 as follows. Page 1 after line 5, insert. This is the A5 amendment.
Senator Dornick to your A5 amendment.
Thank you, Mr. President. I ask for a roll call, too.
Roll call requested, roll call granted. Senator Dornick.
This simply is an exemption for a farmer, a family farm, or a farm corporation that would employ 5 or fewer employees. Now, this isn't a amendment. It used to be a bill that I'm bringing forward. It passed out of labor. It passed out of ag early in session, and it was passed to the floor and has not been heard. So this is a very well-known exemption. It was actually the Senate position last year and was pulled out in the conference committee. One size fits all does not work, and great example of that, and I brought this earlier, is when St. Paul passed the minimum wage law back in 2018 to be $15 per hour. And they did it very carefully and did a nice job of listening to all sides. And again, they broke down the businesses into different groups. The micro businesses, 10,001 or more, and they were to be implemented in 2020. So they passed the bill in 2018, or the mandate for the cities, St. Paul. And then large businesses are 101 to 10,000, and they were in 2023. So a little bit more time. Small businesses, 6 to 100, 2023. And lastly, the small businesses, the micro businesses, and they called them 5 or fewer, has not been implemented yet. So time of implementation and the size of business was very important. And I think that's the same thing with this, the Earn Sick and Safe, that unfortunately didn't get done. But now we're making some fixes, and I appreciate that. So again, this amendment is just for the agriculture, 5 employees or fewer, very small amendment. I ask for your support. Thank you, Mr. President.
Senator Seeberger to the A5 Dornick amendment.
Thank you, Mr. President. I view this as a friendly amendment.
Any other discussion on the Dornick amendment? Senator Rasmussen.
Thank you, Mr. President. I impose a call of the Senate for the remainder of the bill.
The Senate is under call for the duration of the bill. Senator Rasmussen.
Thank you, Mr. President. I move that further proceedings under the roll call be dispensed with and the Sergeant at Arms be instructed to bring in the absent members.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. Senator McEwen.
Thank you, Mr. President. I rise against the amendment that has been offered that we're hearing right now from Senator Dornick. Senator Dornick is correct. This amendment was also drafted as a bill, and it has been offered previously as an amendment in the Labor Committee and was passed, to my sadness, in a bipartisan fashion out of the Labor Committee. It's hard for me to know sort of where to begin talking about what we're dealing with today on the floor of the Minnesota Senate. I'm going to go ahead, Mr. President, and try to keep my comments as narrow as possible to this particular amendment and save my screed for the end after the third reading. But I will say that this amendment in particular would affect somewhere, and when I say affect, I mean would take away the basic workers' rights to earn sick and safe time that these workers now have, that they have had for about 16 months now, would take away the right to earn sick and safe time and all the protections that go along with that right for those particular workers. The numbers that we're talking about are estimated. We have an estimate from the Department of Labor and Industry that 5,000 workers fit into this category of worker. So 5,000 Minnesotans work for these small farm businesses that would then be exempted from having to provide these rights to their workers. 5,000 on the low end, that's from the Department of Labor and Industry, but from USDA data from 2022, Minnesota had 26,869 workers working in these positions. There were 13,359 farms with 1 to 4 employees. So a total from those farms of almost 27,000 workers. And I think this really goes, Mr. President, to part of what I am really incensed about and have been incensed about when I've seen this amendment come forward in the Labor Committee is that these farm workers are some of the least protected, powerless workers in our society in Minnesota. They don't have lobbyists here at the Capitol paid 6 figures coming to argue their case for them. And when we figure out how many of them are there that are going to lose their rights with this amendment, we don't even know if on the low end it's 5,000 or on the high end it's closer to 27,000. We just don't know. Workers count on these rights. And it goes back to the basics of why we passed an earned sick and safe time law in the last biennium. That no one, not a farm worker, not a tradesperson, not a nurse, not a teacher, nobody, no worker in our economy should be fired or disciplined or risk the ability to provide for their family because of a short-term illness that they have, because of the need to care for a sick family member, or because they've suffered domestic abuse or sexual assault or stalking and they need to seek out help for that. Farm workers and people who work in these situations for smaller farms need those rights too. They need them just as much as other people need them, and they have them now. So members, I hope you take a hard look and think deeply about the vote that you're about to take on this amendment. What you will be voting to do is to take away rights from Minnesotans, tens of thousands of Minnesotans. Workers that don't qualify for workers' compensation and who've also been written out from a lot of the other workers' protections that we have and that we enjoy here in Minnesota and nationally, the right to form a union and collectively bargain, the right to workers' compensation. In many instances, they don't have the same rights to minimum wage that the rest of workers have. So this just is talk about picking the low-hanging fruit and picking on the least powerful people. I'm ashamed that something like this passed out of the Labor Committee, and I believe that this body should be ashamed if it passes on to this bill and then moves forward. And Minnesotans should know, I hope that they are listening, that this effort is not just coming from a Republican Party that is well known to be dominated by the concerns of the business community in the chamber, but is also coming out of the so-called Democratic Farmer Labor Party, ostensibly in a bipartisan manner. It's shameful. So members, I respectfully ask for you to reject this amendment wholeheartedly and vote no.
Senator McQuaid.
Thank you, Mr. President. I wonder if Senator Dornick would yield for a question.
Senator Dornick, will you yield? He will yield. Senator McQuaid.
Thank you, Mr. President. I'm wondering if Senator Dornick could explain to me the correlation between the size of someone's employer and their need for sick time, or how often they get sick.
Senator Dornick, to the specific question.
Thank you, Mr. President, and thank you, Senator McQuaid, for the question. My concern, the big concern we have is businesses are not staying in business. So it hurts the employee. So business have choices. They can grow their business, they can start a business, they can stay the same, they can close their business, or they can move across the line where it's easier. So as a business owner myself and talking to many businesses, they're not growing their businesses. They're staying the same, and that hurts the workers. And I grew up on a farm and labor. That's what I've done my whole life as a carpenter. Worked side by side with good, hard-working Minnesotans. And I want to make sure that they have an employer that can keep in business so they can stay in business.
Senator McQuaid.
Thank you, Mr. President. Well, I think I heard the answer there. There is none. There is no correlation between somebody's inability or ability to get sick and the size of their employer. All I heard there was disregard for farm workers' lives, disregard for their health and safety, especially at a time when bird flu is threatening our health and safety. There are a lot of problems facing farms right now. The tariffs, the rising cost of farm equipment, high interest rates, but making sure that their workers come to work sick, infect other people, potentially animals or produce, other people. I just don't know what world we're living in. All I see before me is an amendment to say who doesn't matter. We all have paid sick time here. We all get to stay home when we're sick. Vote remotely, not vote remotely, nothing happens. We all get that. It is the height of ridiculousness for us in this chamber to sit here with all of our paid sick time, all of our paid leave, all of our insured money, and take away paid sick time from farm workers. Especially when earned sick and safe time is not just about illness, but it's about safety. Maybe fleeing a domestic violence situation, seeking out help. I just sometimes I stand here and I'm like, what are we doing? And for who and for why? Everything we do in this chamber should be to make people's lives better. And here we've said, hey, you can have sick time. If you're sick, if you have strep throat or conjunctivitis or the measles, you can take sick time. You won't get forced out of your home or your apartment. You won't go bankrupt taking a sick day. You've had it for 16 months, but just kidding, you're not important anymore. You don't get it anymore. So that businesses don't stay the same, it's offensive. And just because those folks aren't standing outside this chamber or in the rotunda doesn't mean it's not offensive. So members, I urge a no vote on this, not because it's something we could, we have this now, and we don't know how many people won't have it anymore, but it's in the thousands. So today we can say, here are the thousands of people we will say do not get paid sick time anymore because their lives do not matter, The people they work with do not matter. Their health and safety don't matter. To all of us in this room who have what we are taking away from potentially tens of thousands of people, or we can say, no, we should not do that. We should not do this. Vote red.
Senator Weissenberg.
Thank you, Mr. President. This is a great amendment. I have many farms in my district, and I've talked to farm workers, and they like this amendment. Talked to farmers, they like this amendment. I actually work for a farmer, and I like this amendment. So I'm one of these employees, and I realize what it's like to work hard. And maybe farming's not for everybody, and if you don't like farming, you shouldn't do it. But we need to pass this, and like Senator Dornick said, Mr. President, we're putting restrictions on these small family farmers who might have one employee, and if they can't afford to pay, if they have to do this and then they go out of business, where's that person going to work? And I don't think some people realize that farmers work 365 days a year, 7 days a week. They never get a day off. A farmer doesn't get a day off when they stub their toe or they break their ankle. They put duct tape around their sores when they get hurt, and they work. So this is an awesome amendment. Vote green.
Senator Hochschild.
Thank you, Mr. President. Thank you, members. I'm on the Labor Committee. I'm the Vice Chair of the Labor Committee. I'm also a family member of previous family farmers on the border of North Dakota and Minnesota out of Wahpeton, Breckenridge. My grandfather had the Hochschild farm. My uncle took it over. And when my cousin tried to take it over, unfortunately, we were in a position where the family sold the farm. And I will tell you that this is happening all across Minnesota, North Dakota, South Dakota, Iowa, all across the Midwest, right? We are losing our family farmers. And it's ironic, I heard the phrase Democratic farmer labor brought up here, and labor emphasized, and they should rightfully so be emphasized. But what wasn't emphasized was farmer. Because family farms are dying. And the way that family farms operate is they operate among their family to operate their farm. They're small. They're not the big corporate farmers that have hundreds of employees. They maybe have a couple sons and daughters working the farm, and then they call John down the road to help them out every once in a while. They bring in help in certain seasons to plow, to clean up, to haul hay, to milk the cows, whatever it is. They're just trying to get by. And for us to assume that the government needs to tell our small, micro family farmers how to operate their farm in their small community? Come on. Family farmers are just trying to survive. And if we want to put more burdens on our family farmers, all that means is that they are more and more burdened and incentivized to sell out to the corporate farmers. The last thing I want is more corporate farming in Minnesota, and I think a lot of my colleagues would agree with me on that point. But man, when you keep telling people how to do this stuff, they're just gonna sell out. They're just gonna sell out, and we're gonna see bigger and bigger operations. And you know what? Those bigger and bigger operations, they'll fall under earn sick and save time and all these other employer mandates that we have on them, and rightfully so they should, because they're corporations. But that's not going to help the employees feel better about their day jobs, day in and day out, if they're not operating with a family farmer who knows their family down the street, who knows what their personal circumstances are, who know the needs that they have, who understand when they are sick, of course they're going to get a day off. Of course they're going to get a day off because they're friends, they're their employee. In Minnesota, we go out of our way to look out for one another. We have each other's back. We do bake sales when people are sick, right? That's the embodiment of who we are here in Minnesota. And I think family farmers know that. They are the embodiment of that ideology, I think. So let's make this a little bit easier to keep our family farms alive. Let's make it so that they can manage their employees and have those personal relationships and make sure they're cared for in the way that they know how to do best. So with that, members, this is something I've already voted on several times. I have a couple of colleagues that I think could join me, but I think we can provide some reasonableness when it comes to the policies that we pass. And I'll admit, I'm just going to add one last thing. You know, it's okay to pass laws and vote yes, and then learn more information and make changes. That's not a shameful thing. That's not weak, that's strong. It means that you heard the voices of your constituents. It means you understood that a law that you had hopeful intended purposes didn't actually work out the way you were hoping. And you listened to folks and you changed your mind. So we can get hit, we can play the political games, we can shout, but at the end of the day, this is about listening to the people of Minnesota, listening to our districts, and understanding that family farmers are just trying to survive. So members, please vote green.
Senator Dames.
Well, thank you, Mr. Chair and members, and I stand up in support of this amendment. Sitting here listening to the comments being made is quite interesting. Apparently, somebody here thinks that if we don't have sick and safe leave for farm employees, the rodents are worse, machinery is less safe, and the list goes on that I heard the verbiage flying over there, and I think it's quite ironic that all those things can happen just because of sick and safe leave. Just remind the members that a typical farming operation, you have somebody help you for a couple of weeks in the fall and a couple of weeks in the spring. And many a time, the people that are helping other farmers are farmers that retired themselves. And they like to get back into the field in the fall. They like to get back in the field in the spring. And they're not worried about getting sick in this process. They're not worried about getting earned sick and safe leave. They just want the opportunity to get out and help their neighbors, earn a little change, and be back into the system. The other thing that doesn't fit is we have a lot of farmers that work together. I can remember when I was on the farm with my father. He and his brother farmed together. So when it come in the fall for about 2 weeks, they would harvest and handle the grain together. In the spring, they would plant and get the field ready together. Pretty soon we'll say, well, those people need to be included in sick and safe leave. This is a good amendment, and we can talk all we want about it. We can talk about thousands of people are going to be cheated out of their sick and safe leave. Maybe some of you ought to go to rural Minnesota and just work on the farm for just 2 or 3 days. And by the way, see if you could get some sick and safe leave. But work on the farm for 2 to 3 days and just see how it works out and see really how these farms are operated and what goes into this operation. Some of these are small farms, some are large farms. But get acquainted before you speak so eloquently about what you don't know.
Senator Matthews.
Thank you, Mr. President. I rise in support of this amendment, and it is very obvious based on some of the discussion we have on this floor that we have people in this body who think they know all about farms who actually know very little about farms. I grew up on a farm in my home area, close to where I live now, and what you're hearing from some of my members is absolutely right. The family farm is going away. My parents' 40-acre property, when my folks bought it decades ago, was one of the smallest parcels of land in the entire vicinity. Now that 40 acres is one of the largest parcels of land in the entire area, because the farmers that were in the area, I grew up next to a dairy farm. There are other farmers that planted crops in a number of fields, and most of those fields now have houses in them. There's a field off in the distance from our area that had only about 2 or 3 houses in the entire sight line off in the distance that now probably has 30 houses in our sight line. And my colleagues are correct in talking about that even farmers and farm workers are in support of this amendment, because we've got members here on this floor that seem to believe that farmers never helped each other, never reached out to accommodate people in a crisis until the government and the Democrat trifecta came along in 2023 and rescued everyone in one fell swoop with this statewide mandate for earned sick and safe time. That somehow helping our fellow neighbors and workers was a foreign concept for all of human history until we got to 2023. And that's simply ridiculous and far removed from the truth. Farms normally operate on razor-thin margins anyways. Members, you and I in this chamber, as elected members, you will get your government paycheck for being an elected official, whether you do a good job or a crappy job here in office. And maybe you're used to that, been in roles or nonprofits or other government agencies all along where you get your paycheck showing up in your bank account every 2 weeks or every month, regardless of how good of a job performance you do. Our farmers deal with one weather event on one day at the wrong time of year in late spring or early summer could eliminate the entire production for the whole year. A weather incident, a vehicle could break down and have an extra cost for a repair for farm equipment. Drought or too much rain or heat or insects or any of these things all can chip away at what a farmer needs to do to just even manage to get by raising the food that we all need to use to eat. Government came along in 2023 and said, now actually in addition to all of those normal costs, you now have these additional government mandated costs for sick and safe time, which are far beyond what is needed in retrospect to how big a smaller sized farm like this is. And it is putting more pressure on more farms to just go out of business. And so I take offense when I hear colleagues stand up and say, well, you hate the little worker if you don't support our gigantic bureaucratic government mandated safe time plan. When the reality is, members, you are taking businesses away and going to leave more people unemployed who used to have a job to care for their family and now have no job at all and have to go hunt for another one. And so I get very fired up when I hear this outlandish rhetoric on this floor by people who clearly have no picture of what it's actually like. I agree with my colleague here. Get some dirt under your fingernails. Do the work that a farmer is doing. Drive around in an open cab tractor in 95-degree heat all day long because the hay has to get cut or mowed or baled. Get it stacked up in a barn in 100-degree temperatures when you're up in a rafters that doesn't have air conditioning, traps the heat in more, where it can feel like 110, 120 inside of a barn, because the work has to be done. And we're trying to help give a little bit of pressure from these outlandish government mandates that are putting undue pressure on putting more of these small farms out of business. Members, please vote green.
Members, any other discussion before we go to vote on this amendment? Senator Johnson-Stewart.
Thank you, Mr. President. I just want to call out a little bit of double standard here. First off, I'm waiting for anybody else but me to be told to calm down. So let's calm down. And I also want to remind people that we are senators for just a short time, and we have to live with ourselves after we leave. Last week, you might remember the kindness and respect with which I told one of our members in the room who is visually impaired that we as engineers take sight distance into account when we design curbs. If you remember, I did that gently, I did that kindly. I did not mean any disrespect, because his experience is different than mine, and it would have been something I frankly couldn't live with if I denigrated him or said, how dare fill in the blank. I think you know what I'm saying here. We all bring different experiences. It is valid. It is appropriate for us to honor those experiences. I may not have dirt under my fingernails from living on a farm, but I have spent plenty of time on a family farm, having grown up in northern Wisconsin. So let's just calm down. Let's treat each other respectfully, please. And thank you, Senator Champion, or Mr. President, for letting me have a minute.
Thank you, Senator Johnson Stewart. Senator Westrom.
If you complain about farmers, don't talk with your mouth full. That is the bumper sticker my grandpa had driving around on the back of his pickup. Because farming was his life and his standard and his income to raise his family and to have a good life. But it was a hard life. Farming isn't easier. It's gotten much easier. But members, I urge you to support this common sense amendment. We shouldn't even have to be debating this. But let's at least have regard for our small farmers who are doing everything from HR to milking the cows, to planting the fields, to bringing in the hay, to spreading the manure, to feeding the cattle, feeding the pigs, fixing the barn roof, fixing the sheds, fixing the equipment, updating the equipment, getting stuck in the mud, getting unstuck out of the mud, and the day goes on. Many of you probably have heard the Paul Harvey poem reciting about a farmer. And if you haven't, I would urge you go look it up. Because what farmers have to deal with is far more than what we, in a controlled environment here in the Senate, that can't even find time to take breaks, even though we want to make everybody else take a break every 4 hours. And yet we want to run farmers' operations and their lives. And so, members, this would at least make the HR department of our small farmers a little easier and make it a little more affordable. And it's the least we can do for our farmers. And members, those of you that didn't have the opportunity to join us on the Senate Ag Committee about a year ago, out in Melrose in my district, Senator Putnam was gracious enough to take our Ag Committee on tour. Part of it was in my district. And as we left this dairy farm of about 100, little over 100 dairy cows, we asked one of the owners, Sadie, one of us members did, said, what could we take back as advice? And without much hesitation, their answer was, stop the regulations on us small farmers that we can't afford and are hard to implement, to paraphrase what she told us. And it was regulations like this that she was referring to as many new regulations were coming down the pipe. And again, they are the HR director. They are the last to get paid. And they are the ones responsible for all of the duties because our small farmers don't have big HR departments, big offices of staff that can comply with government regulations. So remember, if you complain about farmers, don't talk with your mouth full.
Senator McEwen, before we go to Senator Dornick, who will be the last voice we hear before we vote on the A5 amendment. Senator McEwen.
Thank you very much, Mr. President, for indulging me. I'll be very brief. I just wanted to respond to a couple of comments that we've heard through our debate today on this particular amendment. One of the things that really, I think we should be aware of is this pitting of groups against one another. So this idea that in order to help farmers in Minnesota, what this legislature or this body is prepared to do is to take away basic human rights and workers' rights to ostensibly help farmers. This body is not willing to take on corporate ag, to take on the systemic issues that lead to small farms closing at record rates again and again. This body is not willing to actually adopt the Minnesota Health Plan to make sure that all Minnesotans can actually have health care when they need it, that farmers can go to the doctor. Instead, we say, you know, we can help you. You know that mandate? We know you take care of your people anyway, but you know that mandate that says you have to actually grant and honor the sick time that's earned by the people doing the farming on your farm? We'll take that away. We'll take that right away from them. That'll be helpful for you. Minnesotans, watch out for that stuff. That is a race to the bottom. We are not in a situation where it has to be farmers versus the people who work on their farm. We can lift all boats, and we should be lifting all boats. And when people talk about, you know, it's a good thing that when we pass a law, we see how it's implemented. We see if there should be changes made, improvements made. Absolutely. I 100% agree with that assertion. But let us be crystal clear. This is not just a change. It's certainly not something that is making the law better or serving people better. What this amendment does is take away Minnesotans' rights, period. So I don't like the dressing up of what this is into something nicer than it actually is. It's taking away people's rights. And I've said this before on the floor of this body, but when we hear mandates over and over again, I hope that the people of Minnesota will ask their elected officials, ask the people in this room when they go out to town halls and they're back in the community, when they say all these mandates, say which ones? Because a lot of those things that they're talking about are your rights. The rights that your employer has to honor. The rights that our society recognizes that you have. They don't want those. They're saying those should go away. I thought of one instance in particular where this amendment would be particularly damaging, and I want to raise it because it goes to the heart of a lot of what the impetus for passing Earned Sick and Safe Time was, and that is to protect people who are in situations of domestic violence or who have an issue with assault or stalking, and they need to seek out some help. And there's good reasons for the provisions and protections within our Earned Sick and Safe Time laws, and that is that this time is for the employee. They can take it when they need it. They don't need to go to the boss and let them know all of the reasons why. They just get to take that time. So I think we can all imagine a situation. Someone might be working for an uncle or a family member on their farm doing work. Maybe they get even some Earned Sick and Safe Time from their family member. Maybe this amendment passes, it goes into law, and their uncle still gives them sick and safe time, but maybe it's just then not required by law. It's not a mandate. It's just something that the uncle does that he thinks is nice and that he should do. But it doesn't contain the protections that our law provides. So that includes that if you use your sick and safe time and it's not protected under our laws, you could be fired or disciplined for using it. Or maybe you could be required to give the reason for why you're using it. So you can imagine a situation where someone is working for a family member in one of these situations. Maybe they're experiencing domestic violence in their home. And maybe it's really sensitive, like they don't want to tell their uncle why they need to take the day. They just need to take the day. But now, because of this amendment passing, if it were actually passed into law, they might be under a situation where they couldn't do that. Their job wouldn't be protected if they did that. They'd have to let it all hang out and tell their uncle about what was going on in their house and not feel safe. It belies the whole purpose of why we have earned sick and safe time. And it also goes to just the inherent dignity and trust that we place in people to be able to manage their own situations within their families and their work. It's just so disrespectful. So members, again, I ask you to reject this amendment and to honor people who are doing the farming on these small farms who also deserve the protections that Earned Sick and Safe Time provides.
Senator Dornick, you have the last word, sir.
Thank you, Mr. President. Thank you for the discussion. One thing that bothers me is that we assume the worst. We assume that this family farm is not going to give somebody a sick day. They're not going to pay for this. They're not going to pay for that. It's quite obvious that you don't know what rural Minnesota is like. You don't know what we do for each other. I was taught that on the farm, growing up by my parents. And my dad always said, as a farmer, you don't have to go to work. It surrounds you, and it does. And as kids, we had larger families back then, and you all had your chores and the responsibility to raise animals, to feed the calves. All those things makes me who I am. And watching the neighbors help each other when somebody was sick, somebody had an issue, were in the hospital, the community rallied around that family to help them. Whether it was milking their cows, we had to milk the cows twice a day. And when I was 5, I had chores. And of course, they were age appropriate. But we grew together, we learned together, we worked together, and we became a strong family. And unfortunately, that opportunity isn't near as abundant now because it's difficult to farm, and we're down to under 2,000 dairy farmers now. What a great life that was, and many families can't experience because not just this, but other things. There's other things. But this is just one area that gets frustrating, that I'm accused, or we're accused, of not caring for people because we don't support some legislation. That is just not the way it is. Again, this is a small exemption, and the city life and the city area is so much different than the rural areas. I'm not saying there's none, but there's not a domestic violence. There's not all these things that are more prevalent in the big cities. In rural Minnesota, greater Minnesota, we're just folks trying to make a living, to help each other, and we do care for each other. So thank you, Mr. President. I ask for a green vote.
The Secretary will take the roll on the A5 Dornick amendment. Senator Rasmussen, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. I request absentees.
Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Murphy votes no.
Senator Murphy votes no.
And Senator Fate votes no.
And Senator Fate votes no. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Housley votes aye.
Senator Housley votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye. All senators having voted who desires to vote, the secretary will close the roll. There have been 41 ayes and 26 nays. The A5 Dornick Amendment is adopted. Senator Abler.
Well, thank you, Mr. President. I appreciate the debate, and I appreciate the topic, and I appreciate a lot of things about the underlying bill that we passed. I may offer an amendment, but I first have to ask, well, I'm going to not be very long, but I just have to be clear, and I don't want to offer the wrong amendment. But I want to remind people this is the first it's Nurses Week, and one thing that I'm worried about in my amendment I might offer is some of the concerns with the way that nurses taking sick days are treated with some retaliation. There's a letter on your desk. It talks about a company with starting with the name A, which has been particularly egregious about this. And I'm concerned, and so if Senator Seeberger would yield, I'd like to ask her a question about my possible amendment.
Senator Seeberger, will you yield? She will yield. Senator Abler.
Well, thank you, Senator Seeberger. I'm thinking of offering an amendment that says nothing in this paragraph limits the right of parties to a collective bargaining agreement to bargain and agree with respect to paid time off or the paid leave in excess of the minimum amount required in Section 181.9466 for absences from work due to personal illness or injury and the limitations allowed under this paragraph. So, Senator Seeberger, is this an amendment that would be worthwhile to improve the bill?
Senator Seeberger, to the specific question.
Thank you, Mr. President. Thank you, Senator Abler. And I'd like to remind you and the body that I also work for that company that begins with A. Senator Abler, thank you for your amendment, and I would consider it unnecessary because in the bill itself, it contains the language that you just read to me. So nothing within Earned Sick and Safe Time as it exists, either now or after Senate File 2300, should it be passed, would affect any collective bargaining agreement.
Senator Abler.
Well, thank you, Mr. President. That will save us some time. Just a comment, and then I'll sit down. But there are some people in this complex today that are very worried about the effect of this. And I do not think that we should undo any collective bargaining work, either it be state employees or these hardworking nurses and others that count on this. And so as the bill moves forward, I hope this can be surely, I guess it's already in the law. So, but I would actually, Mr. President, before I sit down, urge this company that starts with A to stop being unkind to your staff. Respect the risk and the services that these nurses provide and how important they are. And a nurse should not go to work to get hurt. They should go to work to serve. Mr. President, with that, I will not be offering my amendment. Thank you.
Senator Rasmussen.
Thank you, Mr. President. And first off, I want to thank the bipartisan collaboration that went into this bill, and I really appreciate Senator Seeberger and the many conversations that she's had with members on both sides of the aisle, and also Senator Pappas and Senator Dornick for engaging in those conversations, and even the Department of Labor and Industry. And I wish this bill went further, Mr. President, but I'm grateful that today we have an opportunity to try to make some common sense, reasonable changes that will help both Minnesota employers and employees. And I think it's really important that Minnesota employers want their employees to be successful and thrive, and Minnesota employees want their employers to be successful and thrive. It's a system where they need each other to be successful, and this bill has some common sense flexibilities that I think will be welcome and incorporates feedback that we've been hearing from folks since Earned Sick and Safe Time has been enacted. And I think this bill will make this policy more workable going forward into the future. Mr. President, I did get a call earlier this week from a small business owner in Otter Tail County, and they own a restaurant, single location. It's not a part of any national franchise. It's a family-owned business. And they're seasonal, and when you walk in there, you usually see the husband and the wife both back in the kitchen cooking, and sometimes you'll even see their kids ringing people up at the cash register. It's truly what we think about when we have a family business. And this constituent, Mr. President, talked to me about how challenging it can be to be a small business owner and the new mandates, regulations that are constantly flying at them. And their business has been open for decades. And every season, they're thankful to make it to the next year. And he was talking to me about, he didn't know if with the regulations that we have today, with everything that we hit on small businesses, if he would do it again, if he would go through all of the trouble to get his business set up, and if he would have been successful. And so with that, Mr. President, I'd like to offer the A7 amendment and would request a roll call.
Senator Rasmussen offers the A7 amendment. The Secretary will report the A7 amendment. Roll call requested and a roll call granted.
Senator Rasmussen moves to amend Senate File Number 2300 as follows. Page 1, after line 5, insert. This is the A7 amendment.
Senator Rasmussen has requested a roll call, and a roll call was requested and a roll call granted. Senator Rasmussen, to your A7 amendment.
Thank you, Mr. President. This would bring back the micro business exemption to earn sick and safe time. So if you have 3 or fewer employees, you'll be able to figure this out and work with your employees in terms of how you want to structure this policy. And I think, Mr. President, the reason why this is important is for those tiny businesses that are just starting off and maybe adding their first employee or their second employee. When it's that family business, that family culture, like that constituent who called me, this will make it a little bit easier for that business to get started. And Mr. President, when these businesses start, they hope to expand. They hope to have 10, 15, 20 employees someday. And when they do, they will then have to comply with everything in this Earn Sick and Safe Time statute. But we're giving a little bit of opportunity for those small family businesses to get started and be successful here in the state. And I would appreciate members' support of this common sense amendment.
Senators Seeberger.
Thank you, Mr. President. Thank you, Senator Rasmussen. I'll be voting yes for this amendment, and I'll tell you why. This is the microbusiness exemption that, after a lot of conversation and considering, I included in the version of Senate File 2300 that went to rules, and this is the microbusiness exemption that was amended out of rules. And I'll tell you how I got to the number of 3 or fewer. When we started talking about what is a small business, and when I started hearing that small businesses need relief, I kind of dug into the issue. And with the help of the Department of Labor and Industry, I learned that if we're talking about an employer with 25 or more employees, we're talking about roughly 650,000 employees in the state of Minnesota. And when we talk about workers impacted by what we do here at the Capitol, that is something that I am sensitive to, and I feel like we need to balance it with the needs of our business community. So I thought to myself, 25 employees, that might be a little bit high. So I asked for different numbers. At 15 or more employees, or at 15, we'd be talking about 431,000 workers. At 10 employees, we'd be talking about 315,000 workers. At 5 employees or more, we'd be talking about 148,000 workers. So as I ran the numbers to try to find that balance point, where can we protect the most amount of workers while at the same time offering our smallest businesses the relief that they're demanding and asking for and begging for? This is how I came to the number that we see in Amendment A7. And the numbers I have heard of affected workers throughout the state of Minnesota, or what this would encompass in terms of the workforce in the state of Minnesota, I've heard anything from between 50,000 to 80,000 workers. And with a workforce of 3 million people here in the state, we're talking about 1% to 2% of the people. And Mr. President, a lot of people know here, but I wear a lot of different hats. Jobs interest me, and I go pursue that job. I'm not a politician. I haven't been here very long. I make mistakes from time to time. I started out my career as a lawyer. I worked for a firm for 15 years, and then I went out on my own and started my own firm. And I can tell you it's not easy to start a business. There are a lot of things you got to do, but it was kind of fun. I figured it out. I started my business and I worked for myself. And for many, many years, it was just me. But as business came in and things got healthier and I got more work than I could comfortably do, I hired help. And by the time I was elected to the Senate, I had an associate attorney and a paralegal and me. And the three of us, it was the best time of my life. I was so pleased with my business. It was fun. The people that worked for me were like family. I got my paralegal a kitten, Mr. President. We had an office cat. It was a fun environment. And I was good to my employees because they were so good to me. If they were sick, don't come in. I essentially had an unlimited sick time policy. If you're sick, don't come in. We'll get your work done. It's fine. They didn't abuse it. They were respectful of it. My employees showed up to work. We got the work done. But after 2023, I started to think, is it worth it anymore? I always say the worst part of running a business is running a business. Because there was so much time that I took away from earning money to figure out all the things I had to do. I'm not a tax professional, I'm not an HR person, I'm not an accountant, but I had to do all of those things to keep my business running. And God forbid I make an innocent mistake and miss a filing deadline or misfile something, because now I'm on the phone trying to work that problem out, resolve the fine or penalty that I inadvertently incurred. All the while, I am not earning income, because the way I earn income is spending my time doing legal work and billing. And if I'm doing something else, I'm not earning income. So after the collection of mandates that were passed in 2023, I sat down and I thought to myself, is it worth it? Is it worth it to keep going? And my answer was no. And I shut down my business. After 13 years in business, I closed it. I had 2 offices. I had one in Minnesota and one in Wisconsin. My lease was up in Minnesota at the end of last year. My lease in Wisconsin was up at the end of last month. And it was a sad day 2 weekends ago when I spent the weekend cleaning out my wonderful little office in New Richmond, scraping the lettering off the door, scraping the lettering off the sign, turning my keys into the landlord, taking a last look, and walking away. My experience is not unique. There are other businesses that have made the same decision that I did as a business owner, and that will make the same decision that I did as a business owner, because the regulations are just too onerous. It's not fun anymore. It's too hard. And when people roll their eyes at me and say, oh, you should have been able to figure out, or oh, they make it easy, it's a decision. It is my right to decide when I've reached my tipping point, and I reached my tipping point. So, Mr. President, that's how I came to the number that we see in the A7 amendment. If we can offer, if the legislature can offer some help to our smallest of businesses, I think we should. And just because employees of businesses with 1 or 2 or 3 employees are not covered by our Earn Sick and Save Time law does not mean they are not well treated. Generally, when you rely on a small group of people to keep your tiny but mighty little business going, you're going to treat them pretty well. So I support the A7. I think it's the least we can do for the business community here in the state of Minnesota. And I will be voting yes. Thank you, Mr. President.
Senator Pappas.
Thank you, Mr. President. And first of all, I want to say that I appreciate Senator Seeberger kind of working with me on a number of these changes that are in the bill. And I do support those changes, and I think we have a good bill, and I wish we could just pass that bill the way it is. The problem I see with an amendment and why I supported removing it in Rules Committee is that when you think about how many businesses are impacted, we are actually a land of small businesses, which is wonderful that we have so many small businesses this size. But it does create a problem because if you're looking at businesses with under 4, then 3 times as many workers are impacted, about 110,000 workers, by losing this benefit that they've had for the past year and a half. And that's the basic problem I have with this. Other communities that instituted Earned Sick and Safe Time before we did a state bill, St. Paul, Minneapolis, Duluth, Bloomington, they did not have any kind of carve-outs, any kind of exemptions, and I actually didn't hear from any of them about problems that they had. So in addition to impacting so many workers, to take away not just the time, but also the protections. So for safe time, for example, or for taking care of a family member, not just yourself that is sick, taking a child to a doctor's appointment, all those would be protected under and available under Earned Sick and Safe Time. But the other problem is that it makes it extremely difficult to administer. A small business carve-out of any size will require rulemaking by the Department of Labor and Industry, costing hundreds of thousands of dollars to clarify when the law applies. Is it day by day, depending on how many workers are on the payroll? Is it a yearly average? How does one compute that average? How do you determine the average for a new business? Are franchises and chains treated separately or together? Are all workers counted or only those in Minnesota? And if so, what qualifies as a worker as actually being in the state of Minnesota? And even after rulemaking carve-outs create a nightmare of compliance and enforcement problems when different workers and employers are treated differently and neither knows what provisions of law do or don't apply to them, and where that lack of clarity actually results in more complaints to DLI, whose investigations will be even more complicated and result in more conflict between workers and employers, not less. So for those 2 reasons, that we're taking away a benefit that over 100,000 workers have had for the last year and a half, and because it makes it a nightmare for compliance, I'm unfortunately going to have to oppose this amendment.
Members, I am going to go to Senator McEwen, but I want to see if there's any other folks who want to be on the list before I go to the author of the amendment after Senator McEwen. Okay, we'll go to Senator McEwen, and you are on my list, Senator Gruenhagen. Senator McEwen and then Senator Gruenhagen.
Thank you very much, Mr. President. I also rise in opposition to this amendment. According to the U.S. Small Business Administration data, Minnesota saw net growth of over 5,500 small businesses in 2024 after laws like Earned Sick and Safe Time were enacted. So we hear a lot about how making sure that people's rights are honored is so onerous and hard on business. But the data doesn't support that. I also received some updated information from the Department of Labor and Industry, again, about how many workers this amendment would take away these basic human and workers' rights from. There have been some different estimates floated around. I believe that sort of off-the-cuff napkin estimates at one point were somewhere between 50,000 and 100,000 Minnesotans who would lose their rights if this amendment were adopted. I just received updated information, and according to the Department of Economic Development and Deeds data, the number is at 110,000 Minnesotans. So, again, members, I just want to make sure that people are crystal clear about what they're voting for if they vote for this amendment. We hear a lot in this chamber about the noble pursuits of small business owners. And I think that all of us wish small business owners all the good will and good luck with their business and want them to be successful. But I do think we have to look at truly what are the ways to make sure that small businesses can succeed. And again, making sure that small businesses have what they need to succeed does not entail us taking away the basic workers' rights for the people who work for them. I strongly, strongly urge people to vote no on this amendment and to realize and to think back. You know, again, in this chamber, because of all of that focus on business owners, there's a lot of sympathy and understanding for business owners and the difficulties that business owners face, a lot. And that's fine, that's warranted, but oftentimes what's missing in this chamber is a true understanding of what it is like to be a wage worker in our economy, to have a boss. And anyone who is watching this debate could be excused for wondering, have those people ever worked a wage job in their lives the way that they talk about their bosses? Hopefully all of us have had an experience where we have a really great boss. I know I have, and that's wonderful. It's so great to have a good boss who treats you well, who respects you, who respects your work. But many of us who've worked in wage employment have also had really not very good bosses. And you would think, based on the debate that we're hearing on this floor, that what they're telling Minnesotans, what we're hearing people in this body say to Minnesotans is, you know, don't worry, your boss has your back. If you work for one of those small businesses, what we like to call a micro business, if you work for one of those, don't worry about it. Your boss must, I mean, it's a small business. They must love you. They're going to treat you great. Don't worry about it. It's all good. Those of us who have worked in various wage employment in this economy know that there is no guarantee of that. You could be blessed to have that, but you very well may not have that. That is why we have protections and workers' rights enshrined in our law. And that is why it would be wrong to take them away from this set of over 100,000 Minnesotans. Thank you.
Senator Gruenhagen, and right after you, we want to go to the author so we can hear his comments before we vote. Senator Gruenhagen.
Oh, thank you, Mr. President, members. Yeah, and I rise in support of Senator Rasmussen's amendment. Having started a small business, from scratch, I built it into an independent insurance agency. But let me tell you, members, for those of you who haven't tried that, your chief cook and bottle washer, I worked day and night and some weekends. And there were lots of setbacks. Now today, the Lord bless my efforts, I've got 3 agents and 3 part-time secretaries in 2 locations. That just didn't happen. I wish some of you who know everything about an employer-employee relationship would start your own business from scratch. We need to create a fertile ground for small businesses to start. That means less government regulations, less government mandated laws, especially on small business. Remember, 3M started as a small business. Medtronic started as a small business, I believe in a garage, if I remember right. So having a fertile ground for small businesses to start, and if you do your research, about half of small businesses fail in the first 5 years. And we hear testimony right here on the floor of somebody who had a small business and quit. And no matter how well intended, you need to create a fertile ground. And then as that business grows, then they can deal with some of the mandates and regulations. But let me tell you, Just for those of you who think you're so smart in this area, if you haven't tried starting a business from scratch in the state of Minnesota, I would highly recommend it and live under the laws that you want to pass. Please vote green on this amendment. Thank you, Mr. President.
Senator Rasmussen, before we vote.
Thank you, Mr. President, and I do appreciate the conversation on this. And I think it's important that we get these policies right. And I really appreciate Senator Seeberger sharing her story as a small business owner. And what the goal of this amendment is to create more opportunities for Minnesotans, to make sure that when that tiny micro business, it's really even smaller than a small business, is getting started and hiring that first employee that really could be a family member or a family business, that we give them a little bit of relief. And all of those businesses that start out, they want to exceed 4 employees. That's their aspiration. And with this, Mr. President, with this amendment, I think we're showing that we understand how hard it is to start up a small business and operate, and we're trying to help them out a little bit. I think it's the least we can do in response to the feedback we've heard. So I'd encourage members' support.
The Secretary will take the roll on the A7 Rasmussen amendment. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Murphy votes no.
Senator Murphy votes no.
And Senator Fate votes no.
And Senator Fate votes no. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Housley votes aye.
Senator Housley votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Abler votes aye.
Senator Abler votes aye.
And thank you, Mr. President. Senator Liskey votes aye.
And Senator Liskey votes aye. Members, we're waiting for another vote. This is a great time to remind you to be close to the chambers, because this is what happens when people go off and we don't know where they are. Again, all senators having voted who desires to vote, the secretary will close the roll. There being 38 ayes and 29 noes, the A7 Rasmussen Amendment is adopted. Any other amendments before we go to third reading? Seeing none, third reading. The secretary will give the bill its third reading.
Senate File Number 2300, a bill for an act relating to employment, modifying earned, sick, and safe time provisions.
Third reading. We're on third reading now. Any other discussions on third reading? Senator McQuaid.
Thank you, Mr. President. Members, I urge a red vote. This sucks. People who work with people with disabilities are often the only employee of that person. There's a few different ways you can get home health care work, but that's one way. They might still have earned sick and safe time through their contract. They won't have any of the protections of state law. And now, micro businesses, 4 employees, 5 employees, 3 employees, the wild compliance uncertainty, we've just created a mess. And we've told people that your health and your safety matters far less than the people you work for, that the size of their business is more important to this legislature, this body, than your health and your safety. There is nothing, not one thing. I happen to sit next to a medical doctor on this floor, and I can tell you, there is not one thing about your health that is determined by the size of your employer. Everybody gets sick. Everybody needs paid time to care. The size of your employer does not matter. I was an hourly worker almost my entire life, until almost right before I was elected to the other body. The day that I had my gallbladder removed, I was at work because I did not have paid sick time to stay home. I went from work to the hospital to have my gallbladder removed. And then I had to go back to work too soon because I didn't have paid sick time. And I dropped a shelf. I still have the scar on my hand because my stitches burst open because the job that I did was pretty physical, and my job was to put up these shelves, and my stitches burst open, and I had to go home, and I almost had my car repossessed because I couldn't pay my car loan, which was like $37 a month. It was a very low car payment. I don't think some people in this chamber have enough proximity to that kind of financial pain to understand what we just did here today. It is shameful to put people back, not even like we're debating some hypothetical future. There are people right now, today, that have paid sick time, that have the protections of earned sick and safe time, to leave a domestic violence situation, to get strep throat and stay home or go to the doctor to get it treated, to take care of their 9-month-old who was in the hospital, was in the PICU because she had human metapneumovirus, who go bankrupt because they fall behind on their car payment, that's $37, or their cell phone bill, or can't buy formula that month because of one illness. And we send more people out into the world to get sick, to get other people sick, to get other people sick, and it just continues. Everybody gets sick, it happens. And what we have said today is that in our little privileged ivory tower up here who gets unlimited sick time, we could get elected and not show up for 4 years, and we would still get paid. We have told all of those people that their lives matter less, that their financial stability matters less, that their safety matters less than all of ours, and that the size of their employer matters more to us than the individual worker who needs sick time. Disgusting. I hate this. And we did not have to do it. We already passed the law. There was regulatory certainty across the board. And so here we are, shilling for, I don't know who. I get letters from the chamber, who have many, many members, but their largest members are the richest members. My stitches hurt. That's what it is. I have so much proximity to what that felt like to make bologna sandwiches every day, 7 of them on Sunday, to get me through lunches all throughout the week, hoping and praying I wouldn't get sick and miss that $12.50 an hour wage for one day because all of my finances were tied up in that exact amount of hours. So that's what we're doing here today. We're taking all of our privilege with our unlimited sick time, our unlimited family leave, and saying that doesn't matter to us. That people's health and safety matter far less than the size of their employer. It's a shameful day in this chamber, and workers are going to feel it. Vote no.
Members, just a gentle reminder, we have a long growing list, and so if you can be as short as possible with your speeches. The second thing that I would remind you of is that this is obviously a bill that we all care about, and there's great emotion on both sides, but I want to gently remind you of Section 122 that says no person may indulge in personalities, impugn motives of members, use indecent or profane language, or participate in conduct that disrupts or disturbs the orderly proceedings of the body. As a reminder, that's Section 122 in Masons. With that being said, we will now go to Senator McEwen.
Thank you very much, Mr. President. I second everything that we just heard from Senator McQuaid. She said it all so beautifully. I also wanted to just speak briefly, because I've already said a lot with these different amendments that we've heard. But I do want to make sure that members look to the letters that were distributed on to everybody's desk. The Chamber of Commerce, yes, strong support for this bill. We have a letter from the Minnesota Nurses Association and a letter from AFSCME. I've also heard from UFCW and some other labor unions about their disappointment with this bill. And I think it's really important for us to recognize one really painful part of what this bill represents. If you look at the labor unions who've spoken out to say, please don't do this, this is not a good idea, this is going to hurt our members, and they're trying to advocate for nurses, for farm workers, for the people who would be affected by this bill in really negative ways. And these are labor unions that disproportionately represent women and people of color. Now, this body proudly recently, when it came to protecting workers who work in the mines up in northeast Minnesota, who'd been laid off and who are now receiving unemployment, said, you know, we support you so strongly, we want to go above and beyond. We want to extend your unemployment benefits for a period to make sure that you're able to sustain yourselves, to provide for your families while we wait for those mines to reopen. And I was proud to vote yes on that, because I always want to protect working people in Minnesota. But what I see happening here today is that there really does seem to be one way of treating one group of workers and another way of treating another group of workers. When we talk about what earned sick and safe time means to working Minnesotans, and we had these debates the last 2 years when we instituted these protections and enshrined them in our laws, these benefits, these rights are particularly important for women, because women, unfortunately, still bear grossly a disproportionate burden when it comes to childcare within families. So who is it in a family that most often has to call into work when the child is sick? When they had to go to the NICU, when something happens within the family? Most often, It is the woman who has to call in to work to take care of the family situation. For good or for ill, that is where we are as a society. That falls disproportionately on women. So having these rights to know that when you do have to take that time, your job will be protected. You can't be retaliated against for using those benefits. To have them stripped away, that is going to affect women much more than it will men. So I find these efforts to claw back these basic human rights, these basic workers' rights that matter so much more disproportionately to people who are working lower wage jobs and to women and to people of color than they might to workers who are organized within a trades union who are mostly white and mostly men. These rights might just matter more. And so I find it particularly disturbing that this body, that so many members of this body find it so easy to just say, you know, if I'm balancing the interests of these workers versus what I'm hearing from some quarters are the interests of certain businesses, I'm just going to say, sorry, workers, you lose your rights because I'm going to help these businesses because I think it's really hard for these businesses to honor your rights. I just feel like if we were talking about other workers, this bill would have never even maybe been introduced. It's just too easy for us to say some workers and some work, we're just not going to have their back the way we do other workers. And we may not have that intention, but I promise you that when working Minnesotans come together and they meet in their union halls and they have their meetings and they talk about what is happening here today, they're going to be talking about that. They're going to be talking about how they feel like they've been treated by the Minnesota Senate, disrespected by the Minnesota Senate. So that's just one piece of the argument. I also want to remind people that this is earned sick and safe time. Statistics show that employees on average only use about 34% of their sick time. They treat it like insurance. They earn it and then they bank it just in case for the time where hopefully they won't need it, but they might need it. Then they can count on it. So if those things do happen in a worker's life, they should be able to count on using that. So again, it just pains me so deeply that this body, with a 34-33 DFL Republican split, will most probably vote to take away basic workers and human rights from this many Minnesotans today. I'm sorry to the Minnesotans that this is the state of your Senate, and I look forward to working with people on how we can change that going forward. So I urge a no vote.
Senator Pratt.
Thank you, Mr. President. Earned sick and safe time is one of the most frequent complaints I hear from local small businesses. Local small businesses are struggling under the mandates passed during the trifecta. They didn't feel like their concerns were taken seriously, and the changes in 2024 made it even harder for them to comply, and they felt disrespected. The reforms in Senate File 2300 don't go far enough. I appreciate the A7 amendment today, which raised the limit from 1 to 3 employees for micro businesses, but it fails to address the many other micro businesses that are still struggling. Local small businesses generally treat their employees fairly and with respect. Yet the existing law, as I mentioned during debate when we originally passed this, treats all employers as if they're abusive. Now, I don't know about you, but a lot of my local employers
hire local people to work for them. They hire their neighbors. They hire their friends' neighbors. And their reputation depends on what their employees say about them. Now, some senators today have said, we often talk about the needs of small business owners, but not enough about the wage workers. Members, I disagree. When I was privileged to chair the Jobs and Labor Committee, one of our core values was to balance the needs of employers and employees. We understood that employers needed employees, and we understood that employees needed stable and healthy employers. The original bill upended that balance. I wish this bill did more to reinstate that balance, but I'll support it today because it's at least a start and a compromise, and that's what we should be doing here in the Minnesota Senate. We should be finding compromise and balance. Thank you, Mr. President.
Senator Putnam.
Thank you, Mr. President. Members, when this conversation first began, I felt some degree of comfort with the initial language. I voted against all the amendments and the changes in the carve-outs to the bill. But I did feel some comfort with the original bill because it made it more efficient, more functional, and more effective. And I think that that's something that's often left out of our conversation. Sometimes we feel very excited about a principle here or there. But the thing that is struggling or causing us to struggle politically so much in this country, both locally in our state and in our country, is a commitment to purity instead of to what works to help people. And in this case, I think that this bill, I'm entirely not sure how I'm going to vote yet, actually, on the final bill. But in this case, I think this is something that does provide some degree of balance between the needs of the human beings who have small businesses and the human beings who work there. Because I think that's just as important as acknowledging the dignity and the struggles of people who have small businesses and are starting those businesses, as well as the people who work in them. So to me, this is an issue of balance and thoughtfulness, but all focused through the lens of doing what is most effective to help the most people. And that is not simply righteousness or purity. It's working out details so that things function in a way that actually helps people. And so with that, Mr. President, I'm still not sure how I'm going to vote, but I appreciate the discussion today.
Senator Matthews.
Thank you, Mr. President. As I read through this bill, I honestly still don't like it. As one of my colleagues just mentioned, this bill is not going nearly far enough. This is reminding me of a situation that I had as a small kid with some of my siblings when we all got put on dish duty to clean up after a big meal, and there are pots and pans and piles of dishes everywhere. And I, as the oldest, ended up being assigned to washing the dishes, and others were drying the dishes, and the pots and pans were piled on the drying mat and the towels. And some of my family members, we were all very little at the time, would skip over the pots and pans and the big items that were taking up all the space, and they'd pull out one small tablespoon from the bottom of the pile and dry that and put it away. And there's no space left to do the real work. And we got into a big squabble about not doing this right and stopping me from doing my job with the washing. And it was the typical little kid squabble with your siblings. But I kind of feel that this bill, with the mountains of needs and problems that was created by the trifecta, all this bill is doing is reaching to the bottom of the pile and pulling out one small tablespoon and say, we'll take care of this. And this is still problematic. We talked about all the different ways. This is one of the biggest things I'm hearing in my district. I'm hearing from county governments in my area and local governments and even some school districts, people that are not staffed by bastions of strong conservatives that it seems like some of my colleagues are thinking about, that are telling me routinely this was unworkable, this was ill-conceived and ill-thought forward, and we are getting financially bankrupted because of these mandates passed by the majority. I've been amazed at who I've been hearing it from in my district. It's not been just widespread strong conservatives, but a large cross-section of communities in local governments and small businesses have told me just how problematic this is. I had small businesses that still, up to a year after we passed the initial law, were reaching out to my office that were just learning about it for the first time, likely as their accountants were telling them what they're going to need to do for compliance as we turned the calendar year. And I had small business owners calling up my office going, "What the heck happened in state law?" And I had to tell them, "Yeah, you're about 9 months late to the party. They did this to you without your input or your advice, and you're about 9 months too late." I had a small business in my area that does a really good job of employing local folks. I know a number of people that have worked at this small business. They're a small manufacturing company that hires a decent amount of locals for their facility. And this woman business owner provided me with the numbers of what this looked like in their small business from the last year before the law got enacted and the first year after it took effect. And the amount of leave hours at this one small company grew by a margin of 2.5 times what it had been before. And the business owner provided it to me to demonstrate that this was not workable. Again, as I was saying earlier about these farms, often these small businesses are running on very tight margins, already burdened by excessive regulation in multiple areas, whatever segment that they work in. And for government to come along and dump another giant mandate on and say, "Here's the way you have to do it with your workers at your cost with no recourse or other option for you." It benefits the big businesses by driving away all the small companies. And I hear the argument over and over again about how this is an attack on workers, but that's not what I hear on the ground floor. Because the original bill from the trifecta, when you put businesses out of business and have these workers that used to have jobs no longer have jobs, that's even more harmful to the worker than before. And the majority seems to think that no one ever tried to work out an arrangement or work out to help someone in a personal crisis or accommodate when there is something difficult going on. And yes, we know there are bad actors in each segment, but we're painting with broad brushes and blaming everybody for the bad actions of a few. And it's just simply not true that no one was reaching out or accommodating or finding ways to make it work in their business before the all-wise and new laws came in effect that said, "Here's the way you have to do it." Our caucus even had free market family leave options that we worked on diligently for multiple years and tried earnestly to pass into law, and were met with stiff resistance from the other side in here, because in their minds the only way to do it is the government way of doing it, where we get to set up new state agencies and hire hundreds of new state employees to impose one-size-fits-all mandates on businesses of every size and tax every single business owner and worker in order to fund it. We had a much better solution and a much better option to accomplish that. Unfortunately, we are where we are, and we have to work on righting the wrongs that have been done in order to help protect the workers and in order to help protect and make sure that businesses are there and are in strong positions for those workers to care for their families and to grow and thrive in their community. So while this bill is just simply pulling a little tablespoon out of the pile and dealing with that while ignoring all the large dishes that are remaining undone, I am going to vote for this bill And I look forward to the day where we can start working to undo even more of the damage that has been done and get better solutions to accomplish this for the workers to help our families thrive. Thank you, Mr. President.
Senator Mitchell.
Thank you, Mr. President. When this bill was opened, one of the stories that was told is of people abusing this. And I would like to say, while I'm sure someone somewhere has taken a claim to sick day when they weren't actually sick, the reason that we have an ever-increasing wealth gap in our country is because there are far more companies that take advantage of workers and try to deny benefits and basic living conditions and wages and all those things than there are people occasionally taking a sick day that they shouldn't have. In fact, that's why we have to have so many laws to protect workers from things like underpayment, misclassification, taking advantage of people without legal status, unsafe working conditions, wage theft, all of those things. In fact, wage theft, for example, is more likely to happen with small businesses than it is with large businesses. So while there's a lot of wonderful businesses, the fact is there's also a lot of places that someone could be almost on their deathbed and they would not care if they could make a profit. The example I can give of this is that before I was elected, I worked for 2 media companies. One was more corporate, one was actually family owned. I had a foster baby that was medically fragile and very premature, who unfortunately got RSV, and we ended up in the hospital. It was the family company who was known for trying to kind of scrimp any way they could with their employees, that even though St. Paul at the time where I was working had earned safe and sick time, tried to deny me one of the shifts I claimed. And I had to go back and prove that I had been scheduled for that shift because they were trying not to pay me, even though there was an ESST law. And that was a family-owned company. So while we have good ones, we also have ones that will do anything that they can to make a buck on the back of their workers. Whether the worker is sick, whether they have a child in the hospital, whether they're trying to escape from an abuse situation. And our job, at least in my opinion, is to protect the people at their most vulnerable. And this, to me, is what this law is about. And that is why I do not think we should be watering it down, because we just trust that because a company is magically smaller, they're all going to be nice to their employees. I just can't buy that. So I would rather we keep a standard to make sure all employees are treated with basic dignity in these situations than to erode a law that we worked so hard on. Thank you, Mr. President.
Senator Hochschild.
Thank you, Mr. President and members, for this lively debate. I want to just personally also say thank you to Senator Seeberger, and I know Senator Rasmussen and a few others worked on this legislation. And it's not easy to take on legislation that can become such a controversial topic. And I want to talk about absolutes, because it's very easy in political debates to talk in absolutes. It's very easy to go to the extremes and use straw mans to make an argument about policies, rather than digging in, rather than looking at on the ground how this actually is implemented, what the effects are of a law, talking to constituents who are small business owners, family farmers, who are part of the labor movement, who are business leaders and chamber members who show up at the lunches to talk about how can we make businesses thrive. Because the truth is, when business is successful, labor is successful. And when labor is successful, business is successful. That shouldn't be a controversial statement. That should not be a controversial statement. I'm a labor guy. I consider myself a labor guy. I represent northern Minnesota, a place that has a history in the labor movement. I believe in doing everything we can to strengthen workers' rights. But we have to remember that the policies and the mandates that we pass at a state level have an impact on employment. If workers don't have a job, they can't earn sick time. If workers don't have a job, they can't earn sick time. I think first and foremost, we as Minnesotans should focus on ensuring that folks have a job. We should also be a place where business is incentivized to invest, to grow, where entrepreneurs feel inspired to create the next Fortune 500 company. Because we are a headquartered company in Minnesota, because Minnesotans came up with business plans and grew their businesses into these 100 and 1,000 employee businesses that thrive here in our state that we're proud of. That doesn't just happen. Those things don't just happen. We have to foster an environment where people can thrive and where labor can thrive. It's been interesting hearing this debate about exempting 3 or 4 employees and about what that could mean. I want to take a second and talk about some of the other states that have implemented earned sick and safe time in their state. For example, Maryland, a state that's known for its conservatism, exempts 15 employees or less. Massachusetts, boy, that's a conservative state. They exempt 11 employees or less. Should I keep going? Michigan, that's a pretty comparative state. They exempt 10 or fewer employees. I'm going to keep going. Oh, this is a good one. New York. New York. Less generous than Minnesota. Now they're at 5. Do you think the progressive champions in New York City weren't trying to look out for workers because they exempted employers with 5 or fewer workers? Come on. Come on. This is about making sure that our state works, that it incentivizes business, that it incentivizes employment, that it makes sure that labor is supported. For gosh sakes, if we didn't have the 34-seat majority in the DFL that we have right now, earned sick and safe time wouldn't even be law of the land. Paid family leave wouldn't exist in the state of Minnesota. And to my colleagues across the aisle, I appreciate the debate. I appreciate working on these issues together. But you guys have talked about it yourself today on the floor. You wanted a private plan that would cover hundreds of thousands less employees than the programs that we've implemented as a DFL. So that's where this debate is, right? It's about one side putting forward ideas, the other side debating them. We see how the impacts are of those laws, and then sometimes bipartisanship happens. Bipartisanship, where you work with the other side, where you listen to maybe constituents that didn't vote for you. Can you imagine? Can you imagine? You listen to all of your constituents because once you are elected, you represent all the constituents in your district, all 85,000. Not the ones that voted for you, not the ones that are part of a group that endorsed you or sent you money. You listen to everyone because that's our job. We're grown-ups. We are senators for all of our districts and all of our constituents. I really think we have to be grounded in reality in this debate, folks. We're exempting 3 or fewer employees. We're making some changes that make sure that our school districts can operate in a functioning way so our kids can get a proper education. These are reasonable changes, and it's still, I want to reiterate, Minnesota will have the most generous earned sick and safe time policy and paid family leave policy in the country. And I'm proud of that. But that doesn't mean that I'm not willing to make a couple of changes here and there that help make sure that Minnesota can be competitive statewide. Minnesota needs to be a state that works. Let's make some simple changes to make sure that can happen. Thank you.
Last 2 speakers will be Senator Rasmussen and then the bill author. Senator Rasmussen.
Thank you, Mr. President. I appreciate the robust debate on this important topic today. And while I wish that this bill went much further and was more responsive to the feedback that we've heard from small business owners across the state, I will be voting for this bill today and encourage members to support it because it has meaningful improvements that will help Minnesota's economic vitality. And I think, Mr. President, what's maybe even more important than the merits of this bill is listening to Minnesotans right now. And what I'm hearing from Minnesotans is that they want us to work together and listen to them. And I'm grateful for the bipartisan collaboration on this bill, the many conversations, the give and take. And Mr. President, we're going to need more bipartisan collaboration just like this if we're going to get a budget passed on time in the interests of Minnesotans. And so I'll be voting yes. I encourage members to vote yes. Let's show that we can have bipartisan collaboration and be responsive to feedback we've heard from our constituents.
Senator Seeberger, last few words before we go to final passage as amended to Senate File 2300.
Thank you, Mr. President. I'm proud of the bipartisan work that we've done today, and my commitment, again, I will reiterate, is to continue working with my colleagues across the aisle to find common ground and to enact common sense policy that benefits the majority of Minnesotans, not just those on the DFL side, not just those on the GOP side, but everybody. Similar to Senator Hauschild, I represent, or along the lines of what he said, I represent people that didn't vote for me also. My district is 50-50, and I've said it before and I'll say it again. I represent the people of District 41, not the DFL, not any special interest. And it's my job to take feedback here to the Capitol and do what I can to enact policy that works for my district. And I think that's what we've done here today. In carrying this bill, I bring with me all of my life experience. I talked about my life experience as a business owner and a trial attorney. That's a profession and something that I've done for almost 30 years. It's a good job, good profession. It treated me well. I worked hard to get there. But I am most certainly not rich, and I have never been rich. Even though I hold a law degree and worked as a practicing attorney for almost 30 years, I have never made a lot of money. In fact, when I ran my business, I paid my employees and not myself. I didn't make money on that business. I did it because it was fun, and it provided me flexibility, and I worked with great people, and I did work that I loved. I was happy. I was not rich. When I graduated from college in 1991, there were no jobs. I worked as a waitress. I worked at the Revolving Restaurant in the Radisson in Duluth. It was a great job. I was union. I made like $2-3 an hour in tips, but there were times I could barely afford my rent, which was $265 a month. So I have plenty of proximity to not earning very much money. I didn't have health insurance. Yeah, I was union, but I didn't pay the extra money to get the health coverage because I couldn't afford it. I walked to work because I couldn't afford to put gas in my car. After I came out of law school, almost 30 years ago, with $100,000 in debt, my first job paid me $20,000. I looked it up, that's $41,000 per year in today's money. I was not rich. I had to budget. I couldn't afford my rent, and I had no health insurance. I continue to work today as a paramedic for the company that starts with A. In fact, this past weekend, I worked 2 13-hour shifts. I started at 5 a.m., I ended at 6 p.m., both days, Saturday and Sunday. Saving lives, working with the community while I'm on the phone working on this bill. I make $34 an hour doing that job. I continue to be an hourly shift worker. I work the same 13-hour shifts that nurses do. I have the same experience that nurses do, except I'm out in an ambulance in a field. You know, over the weekend I was scrambling down an embankment to a river. It's lifting, it's hauling, it's doing things with people. I love it. That's why I still do it. But I'll tell you what, I'm 55 years old, and I've been continuously employed and in the workforce since I was 16. My career has not consisted of working in this legislature. My career has been out there, working. When I was a young attorney, my second job, I worked for a firm of about 13 people, attorneys and staff. I didn't get any paid maternity leave. I had 2 babies while I worked for that job. And when my kids were 5 and 7, my husband was mobilized for a year to Doha, Qatar, and I was a single parent working for a law firm that did not respect me as a woman. And all the time I had to go and deal with my kids, the younger of which I've shared before has some challenges. So I was leaving work all the time to solve problems. I wish I had earned sick and safe time. I wish I had the ability to safely take that time and go deal with family matters. So I'm proud of the earn and sick and safe time laws that we passed, because I've experienced what it's like to be a worker without it. So I have plenty of proximity as a worker, as a union member, as a business owner. So when I talk about experiences, I have lived those experiences. And I think it's only right as a legislator that we listen to our constituents, make the changes that benefit the most people. And that's what I think we have done with Senate File 2300. Thank you, Mr. President.
The Secretary will take the roll on final passage as amended of Senate File number 2300. Senator Rasmussen.
Thank you, Mr. President. I request absentees.
Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes no.
Senator Port votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Murphy votes no.
Senator Murphy votes no.
And Senator Fate votes no.
And Senator Fate votes no. Members, if you're in the chambers, please vote. Senator Rasmussen, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Farnsworth votes aye.
Senator Farnsworth votes aye.
Senator Housley votes aye.
Senator Housley votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Thank you, Mr. President. Senator Liskey votes aye.
Senator Liskey votes aye.
Senator Pratt votes aye.
Senator Pratt votes aye.
Senator Duckworth votes aye.
Senator Duckworth votes aye.
And thank you, Mr. President. Senator Johnson votes aye.
Senator Johnson votes aye. Do you also have a vote for Senator Abler?
Thank you, Mr. President. I'm still waiting on one more.
Members, if you're in the chamber, you must vote. Absentee has been called. Senator Rasmussen.
Thank you, Mr. President. Senator Abler votes no.
Senator Abler votes no. All senators having voted who desires to vote, the Secretary will close the roll. There being 38 ayes and 20 9 nays. The bill is passed and its title agreed to. Senator Murphy.
Thank you, Mr. President. I move a recess for the purpose of appointing conference committees.
All in favor say aye. All those opposed say no. The motion prevails. The Senate is now in recess for the purpose of appointing conference committees. The Senate will come to order. Senator Murphy.
Thank you, Mr. President. Is there a privileged report at the desk?
There is a privileged report at the desk. The Secretary will read the report.
Senator Murphy from the Subcommittee on Conference Committees recommends that the following senators be, and they hereby are, appointed as a conference committee on: Senate File Number 2077, Senators Herr, Kunish, Johnson Stewart, Green, and McEwen. And Senate File Number 2370, Senators Dibble, Port, and Rasmussen. And House File Number 2432, Senators Latz, Umuver-Baton, Seeberger, Westland, and Clark. And House File Number 2446, Senators Putnam, Kupik, and Westrom. And House File Number 2431, Senators Fateh, Putnam, and Duckworth. And House File Number 2438, Senators Dibble, Johnson Stewart, Jasinski, Carlson, and Clark. Senator Murphy moves that the foregoing appointments be approved.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. Senator Murphy. Oh, we don't have to recess? Okay. We are now proceeding to the 13th order of business. Without objection, the following senators will be excused from today's session. Dames from 12:40 to 1:10 p.m. Any other announcements of Senate interest? Senator Hoffman.
Thank you, Mr. President. Today I rise once again to make all Minnesotans, their medical providers aware of a condition known as tardive dyskinesia, or TD for short, and those effects who utilize today's prescriptions and antipsychotic medications to help them navigate and enjoy life in pursuit their own happiness. Mental illness, as we know, sometimes can have dire consequences. However, with today's medicines, therapies, and incredible care that our mental health practitioners provide for their patients, life works for thousands of Minnesotans each day.
there is a side effect of taking antipsychotic medications for some in TD, and it's an incredible heart condition. And so the resolution that was introduced today is the companion House resolution that has been introduced in the other body, and also the governor's TD awareness proclamation encourages stakeholders and Minnesotans to advance education, care, and support of people living with TD. And with that, together we can realize the goal of helping decrease the stigma and improve the caregiver recognition and increase the routine screenings and diagnosis. I hope, Mr. President, you will join me in this fight to make our citizens and so many other patients aware of the tardive dyskinesia. And please remind people that you see next week is TD Awareness Week here in Minnesota and across the country. So with that, thank you, Mr. President.
Senator Putnam.
Thank you, Mr. President. On behalf of Minnesota Milk, our friends there in dairy, I want to announce that tomorrow is Ice Cream Day from noon until it runs out. So, members, it'll be in the vault tomorrow at noon, Ice Cream for the World.
Senator Herr.
Thank you, Mr. President. I want to announce the Ducks Unlimited Capital Chapter event, 33rd annual, is tomorrow, May 7th. Door open at 5:30. Location will be at Capitol Ridge. Thank you.
Any other announcements of Senate interest? Seeing none, Senator Murphy.
Mr. President, I move the Senate do now adjourn until Wednesday, May 7th at 11 a.m.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. The Senate is now adjourned.